Good morning, good morning, good morning, amazing law nerds. Also, depending on where you are, good afternoon, good evening, replay crew, good whatever time, date, everything it is as you're watching. Love you. Good to see you, replay crew. Today is Wednesday, July 29th. There's a lot on the docket today, and there's a lot of things that I'm keeping an eye on. One of them is that the TikTok Psychics appeal brief is due today. I was looking to see if there was either a continuance or a brief filed. No news yet, but I'm going to keep an eye on it. Even if it's filed today, we're not going to cover it today because we can't. But I'm keeping an eye on it. So now is my time to remind you, get the Law Nerd app, because if I see it today, I will let you know in the Law Nerd app. But I'm kind of thinking that we're going to see another request for continuance. That's the vibe. That's just the vibe. That's the vibe. That's what I think is going to happen. But we'll see. I'm always down to be surprised. These cases always keep surprising me. It's fine. I have no idea what just happened on my screen. My screen just did weird things. I don't know. Hopefully it didn't change for y'all, but it definitely changed on my end. Do I know what that's about? No. EDB fights with technology all the time. What else is on the docket today? Well, we need to take a look at a newly filed motion in the Kouri Richins case and talk about what's going to happen, because it's the end of July. And when we were sitting at the sentencing hearing and they set the restitution hearing for July, it seemed so very far away. And now it's this week. It's now this week. It's this week. And I don't know if that's going to happen. Why? Because, well, the last thing that the defense filed was a boo-hoo, Your Honor. We think that you were biased. And the judge was like, fine. We'll see if the other court thinks a new judge needs to hear this. So if that hasn't been decided, because remember, Judge M didn't recuse himself. He punted it to the other court. They haven't decided yet. So I don't know if we're going to have a restitution hearing on Friday, but we're going to take a look at the state's filing regarding restitution. There's an update since yesterday in Bryan Kohberger. It's a really quick one. And there is a news story, which I don't cover a ton of, but it is legally related. And it's, we're going to take a minute. We're going to take a minute and you're going to hear me rant just a little bit because it's a thing. So we're going to play the intro. We've got some like OG quick bits to do, and then we'll get into that restitution hearing. As always, everything will be timestamped down below. Law nerds, it's good to see you. I know there have been some playback issues on the YouTube end. That is not on our end. It is not happening for everyone. It is on the YouTube end. If it is impacting you, I am sorry. When the chat changes, there are also some chat bugs going on. I wish we had control. We do not. So apologies. It's not on my end. It's a YouTube issue and I have no control over that. So we have not figured out what's causing it, but it is on the YouTube end. It is not an output issue on our end. I'm sorry. It's impacting some of you, not others. Sorry, guys. That I wish I could fix it. I can't. So changing devices might help. Restarting might help, but restarting the app might help. But other than that, it is not an our end issue, which means there's nothing I can do to fix it. So we're going to roll the intro. We're going to talk about the things. We're going to do some OG quick bits because I got stuff I need to talk about. We need to talk about it. We need to talk about it. So let's go. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Law nerds, let's go. Let's do our first update just with Bryan Kohberger and get it out of the way. Emily, is that really how we feel about it? It's such a quick update because when I went and pulled up the docket, it logged me out due to inactivity. It's going to make me do the CAPTCHA again. I had it all pulled up for y'all, and now it's mocking me. We were all pulled up on the docket, and then it was like, no. Rude. It's so rude. Hold on. It's making me do 2 captchas. We have to just 2 captchas. Here's what I will tell you, and then I will show you on the docket. Bryan Kohberger is appointed a public defender. That's the update. He's going to get a lawyer. Okay. He's going to get a lawyer. And I imagine at some point today, we will see the court approve him proceeding on a reduced fee basis since he is proceeding pro per. So that's what those are the 2 things that I think we will see today, but I wanted to show it to you on the docket because I have seen with this case since yesterday, things going around the internet where people have like edited the docket or the document I showed you yesterday that had the different check boxes for the plea. I've seen that edited. I've seen people showing old ones purported as new ones. I'm just going to show you everything in this case so we have the source documents because A, that's how we do things, and B, I think it's easier for everyone. But here we go. Oh, I forgot to change this one back from the last time we did Brady Bunch squares. Actually, this works perfectly. No, wait, that's the wrong one. Oh, no. Emily, we can't move everything around. Wrong one. Wrong one. Emily fights with technology. But ow. All right. There we go. Order. This is from today. Order appointing state public defender. That's it. That's all. The public defender will be appointed. Emily, is that going to be a conflict? Because he previously had Ann Taylor. I think they will be able to find someone that is not conflicted with Ann Taylor, who has not interacted with her, and they'll be able to find someone who will be able to take this case. I don't think it's going to be that much of a big deal. So what else do I think? I think we didn't go over the fee petition yesterday, but I think we will see the court granting permission to proceed on reduced fees. So I think we'll see both of those things happen. And then we'll see what happens next. I'll keep you posted. They will probably be some small updates. I'll also update them like weekly in the podcast just so we have them. And if anyone misses them on stream, we have those updates there. But with the little updates, we'll just zoom through the little old updates. With little old updates, the TikTok psychic is supposed to file her appeal today. I'm going to pull up that docket. The appellate docket is a UI nightmare. It just is what it is. It just is what it is. But I'll show you what it looks like. We're just waiting to see if she files it. Because so far, not filed. So let me show you this docket real quick. I don't know if we've pulled up appellate dockets much. Bender is Great says, if he was granted an attorney, does that mean he goes back to trial? No. Him being appointed an attorney just means that an attorney can help him argue his request to withdraw his plea. That's all. He has a right to an attorney. He can't afford one. One is being appointed for his request for post-conviction relief. That request has to be granted by the court. I suspect there will be a hearing down the road, but that has to be done by the court. So until there is a court order allowing him to withdraw his plea is not withdrawn. There has to be a court order. Could there be an off chance that the prosecution is like, we don't object, go ahead, withdraw it? Sure. But even if that happens, the court can still say, no, too bad. You made the plea. You're not getting to withdraw your plea. So, period. It still has to be a court order. Disingenuous Coronation says, does the attorney need to be death penalty qualified? No. It would be an attorney that is at least within the realm of post-conviction relief. Most offices, and I don't know about Idaho, but most offices have attorneys that specialize in requests for post-conviction relief. So it will probably be an attorney that is assigned to handle post-conviction relief in addition to appeals. Those two things are different, but that. So no, it doesn't need to be someone who can go to trial tomorrow. And that is such a far afield possibility that wouldn't even be dealt with till way down the road. So let's see. When do we expect an order on the motion? Amy, that is not going to happen. There's a lot that needs to happen before the court even decides if there will be a hearing or not. So this is likely a months long process. So the first thing we need to see is if the court grants a hearing or not. And the prosecution has room to file a motion as well. So this is going to be a months long process. So we'll just wait and see. It's not going to happen quickly. And the courts aren't going to be overly put out in a hurry to get it done. And the attorney who gets appointed is going to need time to also meet with Kohberger and talk to him. So this is just going to take time. So until there's a court order, which is going to take time, he's just going to have to wait. And he has like, what, 4 life sentences plus 10 consecutive. The courts aren't going to be bending over backwards to speed this up. Let's take a look at the TikTok psychic. Let's see. Oh, Amy, you didn't ask it incorrectly. I think you asked it perfectly correctly. So no, it is my job to help interpret the information. And if I answered incorrectly, I just interpreted it wrong and then we'll try again. That's where we're at. Don't worry about it. So hopefully that helps. But we will see. The court has appointed a lawyer for Bryan Kohberger. That lawyer has to actually get assigned the case, which means it has to go through all the office workings. Then we will see which level of prosecutorial office will respond. I don't know if post-conviction work is handled by the state attorney general's office or if it's handled by the local prosecutor's offices. That can vary by jurisdiction. I'm just not sure which it is in Idaho. Then they have an opportunity to respond. Then the lawyer for Kohberger has an opportunity to respond. Then the court can decide what the next steps are. So that'll take sense. That'll take time. Linda, thank you. Emily makes the world make sense. When I speak correctly, and even then, hopefully it's just fine. So again, it's not going to happen quickly. So the time that we're going to look at on here is, again, a months long process. So I will be interested to see if we have a ruling on this before the end of the year. We may or may not. So let's just give it that time. Just if you're set on that time frame, then you know that you're not waiting for something daily. I am sure that headlines will try to fuss this into an urgency thing. For the courts, this isn't an urgency thing, and it shouldn't be for us either. This is not particularly urgent. It is annoying, but it is what it is. Gino in the chat said, I can't believe Kohberger is putting the families through this. I can believe that Kohberger will do whatever Kohberger believes is in Kohberger's best interest. Not specific to him, specific to many, but if there's an avenue, I'm not surprised that he's trying to pursue that avenue because he has time to think through it, lots and lots of time. So he's going to do what he thinks he can do, regardless of anyone else. Kohberger is not thinking of anyone other than himself, I am sure. All right. Let's take a look at this docket, shall we? A real quick docket for the TikTok psychic. This is the docket for the United States Court of Appeals, Ninth Circuit. This is Schofield versus Gouliard. This is Professor versus TikTok psychic. This is the appeals docket. It gives you kind of all the timing. We're just looking at the last order because we haven't looked at that in a moment. This is from June 29th, 2026. Order filed. Okay, well, Emily, back up. Okay. Defective motion. June 29th, 2026, defective motion to extend time to file the brief by TikTok Psychic. Wrong filing type, correct entry, and then they gave her the correct entry form, and then they edited it. They said, we streamlined this for you. We know what you mean, which is probably because she's a pro per. She's representing herself. They're like, we know what you mean. We're going to just fix it. Like, we get it. So they streamlined the request for extension of time to file the brief for 30 days, filed by TikTok Psychic, and then the court entered the filing to correct the wrong filing. And then they filed the order. So this was all done on the same day. They're like, we know what you mean. Again, the TikTok Psychic did this the day that the brief was due. So the brief was due, and then the request for extension of time was filed that day at 9:38 a.m. Pacific, and then they fixed it same day. This is their order. Paper streamlined request for extension of time to file brief, granted. Amended briefing schedule. Opening brief due, that's from TikTok Psychic, July 29th, 2026. Today. Answering brief due, that is by the professor, August 28th, 2026. Optional reply brief due 21 days after service of answering brief, so after responded. All briefs shall be served and filed pursuant to the Federal Rules of Appellate Procedure 31 and 9th Circuit Rule 31-2.1. And then they entered that order at 10:43 a.m. Lone Wolf said, do you have to pay to view all these documents? Yes. And I do. So, yes. And that's why I pulled them up on the screen so we can all just go through them together. Because, yes. And I don't want y'all to have to do it. All right. So what's going to happen with the TikTok Psychic? Well, I don't know. What do you guys think? Do you think it gets filed today? Do you think she asks for another extension of time? Do you think she tries to use all the Kohberger stuff from yesterday to ask for an extension of time, even though the brief wasn't written? Because honestly, if your opening appellate brief is not done by the day it's due, you're kind of screwed anyway. Like, it's not one of those things that you can just be like, it's going to be fine. Like, we can't just wing it. So I guess we'll see. They're pretty specific on what you need to do for your briefs. I think we're just like, if the brief already wasn't done, that we might see another extension of time. Who knows? Maybe we'll be surprised and it'll get filed. Why not? Sarah Boone's lawyers multiple lawyers extended their time to file the appellate brief for an eternity plus. Courts do allow for that. However, there's not a change of circumstance here, and there's not a change of attorney here. And anything that Kohberger did yesterday is irrelevant to her appellate brief. It doesn't mean she's not going to try it, but it's irrelevant. We can talk about the legal significance and how that might play out after her brief is filed. I'm not here to help anybody. Well, I'm here to help the law nerds understand, but I'm not here to de facto help with that. So I don't want to give any ideas. So I'm going to just keep that. We're going to keep that. We're going to keep that to ourselves. But we'll talk about it later. So we'll see what happens. But I imagine that we're not going to get past the news yesterday of Kohberger saying that his attorneys forced him into a plea without it somehow coming up in something the TikTok Psychic files. I will be shocked if it never comes up. And I'm always here to be surprised. So I guess we'll see. Shocked if it doesn't. I will be shocked if it doesn't come up. It doesn't mean it's legally appropriate. It doesn't mean it's going to change anything. I just think it's going to come up. All right. Law nerds, are you ready? We got to talk about the news real quick. We don't always talk about the news. There's some legal news we have to talk about because it's July. And if any of you have ever sat for the bar exam, you know exactly the trauma of July. So when I started seeing this story, yesterday, I had a type of vicarious trauma that I have not experienced in a very long time, because the bar exam is such a singularly memorable, difficult, and wild experience that as I started seeing the story out of Washington State, remember, I did start law school at Seattle University. When I started seeing this come down, my response was, first, I was aghast. And second, I was like, oh my God, those poor bar takers. Those poor bar takers. You can compare it in any big moment in your life where you are geared up for the thing you need to do. You are in the right headspace. You are tapered. You are ready to go. You have studied. You have done everything. And then you get into your massive fucking testing center in like a convention center. And then you wait. And you wait. And you wait. For 6 hours, bar takers in Washington had to wait. And then they fucking canceled it. They canceled the July bar exam. I have never. They waited and they waited and they waited and they waited. And then, well, they sent them home for the day. So they got a very restless night of, are we taking the bar exam tomorrow? And then they canceled it the next day. Now, I don't know if the legal field is still the same, where a lot of people's jobs are predicated on them passing the bar, which means your whole life is in this holding pattern between the bar exam and when you get bar exam results. And in California, that holding pattern is from the July bar exam until the week before Thanksgiving, like the Friday before Thanksgiving. You are in that holding pattern to find out if you pass the bar. I don't know if they've changed that since they cut a day out of the bar. Who knows? So they actually canceled the July bar exam. We're going to get into some of the news articles about it, but they canceled the July bar exam. And I think that the rage of exhausted, bar prepped, recent law school grads is going to unleash in a fury that the state bar examiners have not seen. Because just like getting ready to take the bar exam again, especially if people have jobs that are starting in August, one simply cannot just get ready to take the bar exam again, especially if you are then working a job. And if you had a job that you were prepared to begin because the bar exam was supposed to be done, people probably have vacations scheduled, or smart ones do, where they can recover from the bar exam. You have everything planned around this bar exam and then waiting for results. So to tell everybody, hey, you can go take it in February is not a fucking solution. So let's take a look. Don't worry. Let's take a look at what the bar put out. And then we're going to go through the news. We're going to go through the news that broke about this. I will break it down. But like, hey guys, you can take the February bar is such a bullshit response. And a lot of law students, because they do not work during bar study, have taken out bar study loans. So they have taken out a loan to cover their living expenses during the period of bar study exam. Now, I think these are predatory loans and I could yell about them forever. But if you have to support yourself and you aren't working because you're studying for the bar exam, what are you supposed to do? I mean, other than be independently wealthy, I mean, that would be lovely. But what do you do? So a lot of bar takers take out bar exam loans so that they can pay their living expenses while they study for the bar, because studying for the bar is a full-time job. And so they've planned their living expenses and the pattern of their life and their jobs in a lot of cases around taking the bar in July. So for the bar to just be like, is insane. It's insane. Let's take a look at what the Washington State Bar Association said on their website, shall we? Because this is, for those of you who are like, but Emily, why? Don't worry. All of you who are just like, tell me why, we'll get there. We'll get there. July, I am knocking off my own hat. July bar exam canceled. Look at this. This is from their, that's not what we need. This, Emily fights with technology. This is from the state bar. With what, I don't even know what this image is that they've chosen to do the header of their blog post. July bar exam canceled. The Washington State Bar Association was unable to begin day one of the July 2026 bar exam today for applicants testing at the Yakima Convention and Event Center due to a technology issue. The venue, Yakima Convention and Event Center, has released its own statement addressing the cause of today's disruption. We refer specific technical questions directly to the venue. We do not have sufficient confidence that the technology issue has been resolved to safely resume the exam tomorrow, July 29th. We have made the decision not to continue. We sincerely apologize to the candidates who worked so hard to prepare, and we deeply regret that we could not deliver a successful exam experience today. I don't even know what to do with that. Hey! Go ask the Convention and Event Center. I have thoughts. We will be working to schedule a makeup exam in late summer, early fall 2026. Okay. Affected applicants are also being offered the option to transfer to the February 2027 exam or receive a full refund. A full refund of what? The fee to take the bar exam? Because that's not a refund of your bar study loan if you took one, your bar prep class that everyone pays for, your hotel and travel to the bar, and all the rest of it. People come from out of state to take bar exams in the state where they're going to live and work. Also, not everyone lives near the Yakima Convention Center. So bar takers from all over the state will travel to a testing location to take the exam. So you're gonna refund their admission, but the amount of lost cost could be significant. And I imagine that jobs that are contingent on bar passage within the state of Washington will be understanding, I would hope. But okay, we're gonna try to get a makeup exam. We don't know the date. You could transfer to the February 2027 bar, or you can be refunded your entrance exam fee. You realize that they have to take the bar to be lawyers, right? Like after 3 years or 4 years of law school, and I don't think I know anyone that went to law school without loans. So some amount of student loans. What you can't do is just be like, we could just refund you. You could just not take the bar. Sure. You can't practice without it. Ask Kim Kardashian. Emily, that was mean. It's just true. We will be working to schedule a makeup exam in late summer, early fall 2026, or you could just transfer to the February 2027 exam, or we'll refund you. All applicants testing with approved accommodations will be able to proceed with their exams as scheduled, and we're not impacted. There's the win. There's the win. Everyone who had testing accommodations didn't have the impact of whatever happened at the convention center. So accommodations for the win. You're going to be the only ones that got to take the bar exam in the entire state of Washington, which is crazy. All registered applicants have been notified by email and through the online admissions portal. We are working closely with the Washington Supreme Court to consider any additional next steps. I wonder what that's going to be like. We're trying to figure out next steps with the Washington Supreme Court and looking at each other going, can we sue the testing software? What are we going to do? You know how there is a stress smell sometimes, like at the vet's office? That's what the bar exam is like. It is, you can walk into the testing center and smell the stress. To try to get people to gear up to do that again is so insane to me. It's insane to me. But also, if you are canceling the bar exam, you kind of have to cancel it for everyone. And now you're going to have a new exam to give to people because it sounds like some people have already taken the exam. So let's take a look at the other articles from the Washington State bar examination issue. Actually, no, Emily, you know what we should do first? No, what should we do first? We should go take a look at what the event center has to say. I don't even know how many people took the bar in the event center I was in. It was so many people. Taking an exam in that type of convention center is just such a weird thing. I'm trying to find the event center website, and it is, oh, there it is. It was not easily coming up. Let's see. They do not readily have their statement on their website. All right, I'm gonna have to find it later because I don't see it. But we'll get there. Because it's we'll get there. Let's go to the other stories and then we'll come back to this because I went to see it on their website and it's not readily there. Also, it would have been a W for the bar website to have just linked to their own statement. That would have been helpful. Sure would have been helpful. Let's take a look at a few other articles about the Washington bar exam being canceled, because this is just A, litigation fuel, but B, nightmare fuel. And I am sure there will be more than a few bar takers who are just like, I mean, can we all grab a whiskey and try to issue spot what the lawsuits look like? Are we suing for intentional infliction of emotional distress or negligent infliction of emotional distress? What tort is this? When we signed up for the bar exam, what rights did we sign away? And then for the bar exam, hey, what testing software are you using? And is that the problem? So let's take a look. This comes to us from Bloomberg Law. Washington State Bar cancels July exam over Wi-Fi problems. The July 2026 administration of the Washington State Bar exam was canceled Tuesday after network bandwidth issues prevented test takers from accessing the new exam on the first day of testing. The what? Why is your test Wi-Fi based? First of all, and couldn't you have foreseen this? Like our student, if I was a student, I would be strongly considering whether or not you just sue the venue. Also, not having a paper backup is fucking horrifying. But it sounds to me like they didn't have a backup of the test. This doesn't make any sense to me at all. Like, why in the world are you Wi-Fi dependent? It's insane to me. The July 2026 administration of the Washington State Bar exam was canceled Tuesday after network bandwidth issues prevented test takers from accessing the new exam on the first day of testing. The Chief Regulatory Counsel of Washington State Bar Association said in an email to test takers that, quote, "We do not have sufficient confidence that the technology issues have been resolved in order to push the exam to Wednesday." I would have been like, figure it out. We'll take it Wednesday and Thursday. What do you mean there's no backups? The email said that the Washington State Bar Examiners is working with the test maker, the National Conference of Bar Examiners, to hold a makeup test on September 1st. So what are they supposed to do? Just study more or just retain all the information in your brain? The amount of people who are going to have like full just stress crashes because of this and just be laid out for a couple of weeks with the full adrenaline dump is also awful. Pushing it back a day would be awful. But like, what are we doing? They go on to say that the National Conference of Bar Examiners, which oversaw the first ever administration of its next-gen uniform bar exam, oh, goody. So not only did you graduate from law school, but now you get to be a guinea pig on the first ever administration of a brand new bar exam. Winner, winner, chicken dinner. What could possibly go wrong? This is horrible. This is horrible. This is so bad. If it's Wi-Fi dependent and you know how many test takers are coming, how can you not plan for this? The National Conference of Bar Examiners, which oversaw first ever administration of its next-gen uniform bar exam across 10 jurisdictions on Tuesday, said in a statement that the test takers in Missouri also saw delayed start times, and one testing site in Maryland also saw a short delay. Oh, did they now? Fantastic. That's helpful. Emily, did we hit the pay? Well, yeah, I don't care. Enough. Sorry, y'all. We're going to go to another article about it. But what? The fact that this was even possible, that there was no option for backup, that it was Wi-Fi dependent, and that this test had never been administered before. And instead of rolling out a brand new test in February when the percentage of bar takers is substantially lower, they roll it out during July. July is when the majority of people take the bar exam. If you're rolling out something new, why aren't you rolling it out when there are less test takers? Isn't law supposed to be logic-based? Good Lord. We're not done. So taking a look at Above the Law and their breakdown of the bar fiasco. Emily, are we adding this? Oh, we're adding this to the docket. We're adding this to the docket. I'm waiting to see the lawsuits. And then I'll pull in the lawsuits from California when they had bar exam issues, and maybe we'll talk about that next. Let's see. No, Emily, you were doing better the way it was before. What did we change? We changed something. There we go. Also, if you can hear, my neighbor is perfecting their lawn. I don't know how lawnmowers are the loudest things ever invented, but apologies, lawnards, if you hear it in the background, it's me, not you. Washington just called off its entire bar exam. 6 hours of tech troubles, no questions answered, and a class of grads told to put their lives on hold until September. I would have been sobbing and then raged. Either that or I would have been completely frozen. There would have been crying. 6 hours. Test takers sitting there ready to start the bar exam with issues for 6 hours. And that's where your infliction of emotional distress comes in. 6 fucking hours. That's like a full day of testing. I can't even imagine. Some of you are saying I would have thrown up. Yeah. Can you imagine? I can't even imagine. Because you're so stressed going into that exam anyway, and you've done so much to manage your stress so that you can take the test, and you've walked in ready to sit down and take the test. And then you have to wait, and then you have to wait, and then you have to wait, and then you have to wait. Anyway, getting into this article, I don't want to say I'm Cassandra, but when we flagged yesterday that with the bar exam here, something was about to go horribly wrong, it wasn't exactly a bold call. Something goes wrong every year. The only No. This has gotten substantially worse since the late 2000s. In the early and mid 2000s, things were going wrong, like a bar examiner had all of the booklets in the back of their vehicle and their vehicle was stolen and all those bar exams were just like gone. Those were the types of issues that they were having. These types of large scale issues were not happening until we rolled out, it seems like, only online available bar exam testing. This is wild. All right. The only questions were how and how badly. Washington answered both on Tuesday. The state's debut of the next-gen uniform bar exam, the first ever operational administration of the NCBE's big skills-based reinvention of attorney licensing, didn't just go badly. It just didn't happen. Great. It just didn't happen, like at all. After roughly 6 hours of starting, stopping, and staring at Wi-Fi that never worked, the examinees gathered at the Yakima Convention Center were sent home Tuesday afternoon without answering a single question. By Tuesday evening, the Washington State Bar had canceled the whole thing, Wednesday's second day included, because it no longer trusted the technology to work. Oh boy. Oh boy. Mofish Wow said, what's wrong with pen and paper? I don't think there's anything wrong with pen and paper except that they stopped having exams that could be like printed out and answered with pen and paper. So you can't take an exam that you don't have access to. And if Wi-Fi is dependent, they couldn't even load the exam to then try to answer it. It seems that they had no backup. And the fact that they decided to do the first ever run of this exam during the busiest bar taking. There are 2 bars a year. Wait till February. The other answer that I think is at play here is money. The bars are being administered by outside vendors at this point. And there is a lot of money in that. So, money. And hopefully, when all the lawsuits start to happen, maybe that equation's not going to be as worth it. So, canceled the entire fucking thing. I love how Above the Law has broken this down. Here's how the not a test unfolded according to ATL tipsters and Reddit posters who lived through it. I'm glad that you parsed it instead of me. I'm glad that Above the Law went through their own blog and community forums to be like, hey, everybody, so what was that like? The crux of the problem apparently was 600 plus people in one room trying to get on the same network at the same time, each on their own laptop to take an exam that runs entirely through the NCBE's software. The 8:30 start time came and went. Employees sat while staff, quote, worked on the internet for hours. This is a convention center. Have you never had more than 600 people trying to connect to your Wi-Fi at like a con? Like that. This isn't new. Have you ever played a Pokemon Go event? Like that's not even Wi-Fi. That's just cell that you can't. Like, have you never had more than 600 people at your convention center? Because I can't imagine that that's the case. I can't imagine that that's the case. So, Trig said, wait, on their own laptops? Yes. And the bar softwares are built to block everything off of your laptop and kind of sandbox it so that the exam's the only thing running on your laptop. And if anything else opens, it has systems that detect it. I think you automatically are kind of done with the exam. But again, this has not been something I have had to endeavor in for over 20 years now. It has been 21 years since I've sat for the bar exam. So I didn't have to do this. All of you saying, did they try turning it off and back on? I bet that's the first thing they did. Auntie Fish said, okay, but as an IT support person, I feel for their IT support. Oh, I do too, because I wouldn't be surprised, and this is just me speculating, I wouldn't be surprised if IT raised concerns and everybody was told it's going to be fine. I wouldn't be shocked if IT is like, but we said, but we said, or if IT was never told they were hosting a new bar exam that all went through a different type of software on a different type of website, because I could see that happening too, that IT had no idea that this year's bar exam was going to be different. But there's no backup. It runs entirely through the NCBE software. The 8:30 a.m. start time came and went. Examinees sat while staff, quote, worked on the internet for hours. By around 11:30, roughly a third of the room had connectivity and the rest didn't. At which point the plan became, start the exam for the people who could get on. The room booed. Right. Because if they start on time and then the others don't start on time, what's going to happen when they finally get to start? And are you then allowed to ask questions about what's happening with the Wi-Fi while other people are taking their exam? Like that's terrible. But I love that the room booed. The Washington State Bar General Counsel, by all accounts, the one person on site doing her best, relaying updates over a microphone as she got them, called the company and secured everyone lunch and a 12:45 restart instead. Dude, that's a W. That's a W. That's a W for General Counsel, because General Counsel is a fucking lawyer. She's like, maybe if we feed them, it will be fine. If we give them free lunch, maybe they won't actually riot. That's a W. It's not going to fix it, but that will at least prolong it a little bit. And General Counsel means she has taken this exam, but I feel for her too, because I like that it's just like, by all accounts, the one person doing her best. And I appreciate that at least those in the room acknowledged, like, that there's nothing you can do to fix this, but also this is your problem because this is the company that you guys decided to work with, and this is the location you decided to have it in. So even though you can't make the internet appear, this is on the bar. The next paragraph starts with, chat. This is not me. I'm reading the article verbatim. Chat. The internet did not fix itself over lunch. The general counsel, by all accounts, the one person on site doing her best, relaying updates over a microphone as she got them, called the NCBE and secured everyone lunch and a 12:45 restart instead. Chat. The internet did not fix itself over lunch. Organizers tried again anyway, and for the lucky few with connection, the NCBE app crashed or failed to load for most of them. That's fantastic. And the head proctor's internet went out. No one ever actually started the bar exam. Examinees described people crying and throwing up in the convention center. I imagine there were other bodily functions happening, but yes, this is that meme of crying and throwing up all at once. Yeah, the whole thing. All of it. Yeah, all of it. All of it. And I don't think that's hyperbolic. I think that's, yeah, yeah. Mm-hmm. Figgy Compass said literally screaming, crying, throwing up. Literally. That level of stress, oh my God. I can't even imagine how miserable this would have been for them, which is why I pulled up the story, because it's just so fucking awful. The headline raised like a visceral reaction to me, and it's been 21 years since I've taken the bar exam. And I still have my letter that says that I passed the bar exam. And most people that I've ever asked still have theirs too, just in case. Which is also why I get so outraged at like the Murdaugh and Girardi of it all, because it's like, do you think Alec Murdaugh and Tom Girardi have a copy of their bar acceptance just in case somebody's like, hey, did that really happen? No. Two of them don't give a fuck. But for those of us that do, yeah, we still have a copy of it. For sure. I don't even know if they mail you that anymore. People might have to have a screenshot of it. So, continuing on. Examinees described people crying and throwing up in the convention center. In the moment they were told they could take a refund or come back in February, which is not what test takers who have spent the better part of 2 months cramming for an exam want to hear. Yes. At that point, I might have stood on a table and gone like, I don't know, full like William Wallace. Like, no, fuck it, pass us. Tell Longshanks that Scotland is free. Like, what the fuck are we doing? Chat, we ride. Like, just riot. Just absolute. What do you mean? What do you mean you can have a refund on the exam that you must take to practice in the profession that you probably just spent at least $50,000 to a couple $100,000 to obtain, depending on where you went to law school, to be told, hey, everybody, I mean, you can get a refund or come back in February. No. Finally, also, I imagine that there were law schools that were like internally torn about how they responded, because you do have representatives from the bar there who do still have to allow you to become members of the bar, and you still do have to pass all the like professional responsibility and ethics portions of the bar and the background check. And so if you're the one person that starts flipping tables, deciding to riot, even if you do pass the bar exam, they might still not pass you on like the moral turpitude because you started a riot, even though it would be absolutely justified. So I imagine there were many sitting there going, how can I even respond in this moment? Because you still have to pass the moral turpitude part of the exam. So no, you can't get completely unhinged, which is also going to be in the back of your mind. It's just awful. So let's see, where were we? I feel for these bar takers. Finally, they were sent home with word that testing would resume the next day and continue to Thursday. Many already scrambling to extend hotels in a city a long drive from Seattle, where 2 of the state's 3 law schools sit with ruined flights and no representation that anyone would be reimbursed for any of it. Right, your law schools in Washington are Seattle U, Washington State, and Gonzaga. So 2 are in Seattle. 1 is on the other end of the state. But if people live in Seattle and studied in Seattle, then they would be taking it there too. So trying to extend hotels, change flights, and the rest of it. Sorry, UW. Thank you, N7 Fish. That's absolutely what my brain meant. We spent too much time in Idaho adjacent to Washington yesterday. So you've got 3 law schools. You are a long drive from Seattle. You've got people who are already stressed the fuck out. And now they're being told, hey, your exam that was supposed to end Wednesday, now it's ending Thursday. Good luck. Good luck, everybody. Then it turned out that there would be no next day at all. Can you imagine fighting to extend your hotel or your flight or rearrange plans and then being like, JK, everybody, JK, everybody, JK. But I'm getting ahead of myself, the author says. I love the cheek of all of this, but I'm getting ahead of myself, the author says, because to hear the NCBE's, the folks that designed the exam, version of events, this was not but a blip on the radar, according to their statement. Oh, it's hyperlinked. W. We're going to go look at that. According to their statement, today was a historic milestone in legal licensure, with the inaugural administration of the next-gen uniform bar examination and the next-gen testing platform performed as expected throughout today's administration. Most applicants successfully completed day 1 testing as scheduled, and the overwhelming majority of testing locations across participating jurisdiction administered the examination without incident. Okay, here's the thing. If I'm the testing company, if I'm the testing company attorney, here's my position on this. This wasn't the testing company issue. I mean, I think it's completely short-sighted to be reliant on Wi-Fi and not have a backup and not have any other contingency plan, but they're going to put it on the testing location. They're going to put this on the test center and saying it's not our fault your internet didn't work. That's on you. Your internet should have worked. That was a load issue on you. But if the app and the website were crashing, that's not necessarily the internet issue. So, but I can absolutely see the testing software just being like, it's fine. It's all good. Terry asked, why hold it at Yakima, not a large city? It's probably cheaper for the bar examiners to hold it at the Yakima Convention Center, or they've determined that it's more centrally located for the bar examiners and easier for people to get to the bar exam and stay in hotels near the bar exam. So I would imagine cost is the first thing on that, because you still have to rent out the testing venue. Somebody still has to pay for the venue. And then most bar takers are staying at hotels near the venue. So, but I don't know. I would imagine there is some amount of money. It goes on to say, as for what went down in the Evergreen State, it said this, tidily pointing the finger. Washington, Most standard time applicants were impacted by site-specific network bandwidth issues. After extensive efforts by local testing staff and the convention center technical support, the jurisdiction determined that the bandwidth issues could not be resolved in time to complete today's administration, and applicants were dismissed for the day. The jurisdiction is evaluating next steps, including whether testing can resume tomorrow or whether affected applicants will instead be offered an opportunity to sit for a future administration. Thank you. Bye-bye now. Click. What? The bar. It's them. It's the site. You picked the site. It's the location. You picked the location. How do you have an online only exam? What the fuck? Everyone's just going with, nah, it's on the convention center. Y'all picked the convention center. Oh my God. They go on to say Washington did evaluate next steps, and in an email from the Washington State Bar to the applicants available in full below, they call the entire July bar administration off. With deep regret, the email begins, Washington's July 2026 administration was canceled. There would be no attempt on Wednesday because the association did not have sufficient confidence that the technology issues have been resolved. And then came the word that the NCBE never managed. We sincerely apologize. So let me get this straight. The test takers sat through 6 hours of technical delays. Then were told the exam would continue Wednesday and Thursday, then scrambled to make arrangements for Wednesday and Thursday, and then got an email saying, it's with deepest regret that we will not be proceeding with the bar exam in July. Thank you so much. We sincerely apologize. Bye-bye. What? An email? An email. And you know what? No one is going to get reimbursement for the cell phones that were broken by hurling them across the room. Are you kidding me?
Emotional damage.
Just the level of what the fuck. We sincerely apologize. I can imagine all of the test takers reading that and being like, fuck you. We sincerely apologize. Fuck you. What do you sincerely apologize? You sincerely apologize? Are you kidding me? Thanks for that. That's wonderful. Applicants were handed 3 options with the decision due by August 14th. Oh, and there's a fucking deadline. You have to tell us by August what you're going to do. They have the audacity to have a fucking deadline. Applicants were handed 3 options with the decision due by August 14th. They can sit for a makeup exam that's not yet scheduled. Tentatively September 1st and 2nd in Tacoma, not Yakima. Right, because people are going to walk into the Yakima testing center and vomit immediately from the stress. Sorry, we're going to move it to Tacoma. They can transfer their application to February 2027, also in Tacoma, or they can withdraw entirely for a full refund of their application and examination fees. Though the NCBE's separate technology fee is a conversation applicants will have to have with the NCBE themselves. We can refund you for your testing application fees and your exam fees, but not all of your exam fees because there's a technology fee that goes directly to the company that administers the exam, only on Wi-Fi, that didn't have a backup plan. So you're going to have to take that part up with them. Are you fucking joking? And then what do? Just not become lawyers? How is that an option? You've just spent 3 years going to law school. Would you like to piece out of the entire profession now? Your choice. What? Kay Davis in the chat said, but it's the technology that broke. Here would be my argument if I'm with the technology company. I'm not saying I agree. They're going to say, no, the majority of our test takers had no issues. This is a testing site location issue, and we are not in charge of the testing site. Having connectivity is something that was known about when the bar examiners, the state bar, picked a testing location. So it is up to the state bar to pick an appropriate testing location when administering this exam. This is not an issue with our software. That's what's going to happen. They're just all going to go like this. They're all just going to go like this. Nope. And it's all going to end up back on the testing location. That's how that's going to get argued. No one's going to stand up and say, hey, we'd like to help. Everyone's going to point their finger at the testing location. But ultimately, the state is responsible for administering the bar examination. So the first level of blame goes to the state for either not adequately selecting a testing location to handle whatever newfangled tests they are rolling out, or for not advising the location of exactly what the needs would be of their test takers for this new test being rolled out, or a combination of the above. Ultimately, it goes to the decision maker, and the decision maker here is the state bar, who is a government entity, so good luck suing them. But I imagine people are going to try anyway, because of course they will. So, they've given applicants the opportunity to take 3 terrible options and have an August 14th deadline to pick one of those 3 terrible options, which include peace out of your profession or don't take the bar in Washington. And if you've always lived in Washington, if you've grown up in Washington, and if you want to stay in Washington and be a Washington lawyer, then you have to pass the Washington bar. Not everybody's going to be like, fine, I'll move to a different fucking state then. And even if you do want to move to a fucking state, you still have to study for a different bar exam and then go take it in February. That's a terrible option. We'll just refund you. You didn't really want to take the bar anyway, did you? I mean, you spent your entire summer studying for the bar. You probably spent at least $15,000, if not more, on all of the bar study, everything, in addition to the thousands, tens, or hundreds that you've spent on law school, but you just want a refund, right? Or you can take it in February, and if you have a job contingent on passing the bar, they may or may not be sympathetic. I would hope most jobs would. Also, Washington bar takers, if the job that you have lined up is a dick about this, you don't want to work there. You don't want to work there. If anyone's a dick about this, you don't want to work there. Lawyers, if lawyers do not meet you with empathy, going, oh my God, that sounds like a nightmare, I would have vomited. You don't want to work there. You don't want to work there. But also, you have your life planned out for after law school. You have the time set aside to take the bar, and then it's over. You have a deadline. It's like getting to the end of a marathon, and then they're like, hey, cool story. So you have like a week, and then you just need to do another marathon. I know you weren't planning on it, but this one just didn't count. No, I know. We got to the end of the whole marathon, but this one doesn't count. You just have to do it again. What do you mean we just have to do it again? I mean, unless you're like Michelle Carre and you sign up for that and you know that in advance, you can't just get all the way to the end of the thing and then have to go back to the beginning and start over. So doing it in February is a terrible idea. Not to mention, do you try to find a job in the meantime? If you're not working after law school because you were studying for the bar, do you ask a job that you might have been starting in August to, well, delay you starting until after the bar exam in maybe September or maybe February? The amount of mess that this causes has incredibly large ripple effects. And we haven't even covered all of them. But don't worry, everybody. Don't worry. They sincerely apologize. It's fantastic. So, the The bar said that it will work with the Supreme Court on further steps. Each one of those options, and this is continuing back to the article, each one of those options shares a feature. Each one bills the applicant for a failure the applicant did not cause. More travel, more hotel nights, more weeks of unpaid limbo, or withdrawal, which seems like a non-starter for people who, went to practice law in the state. This is Emily, just fucking keep reading. The author says the shittiness of the options was highlighted by a rightfully irate ATL tipster, and ATL is above the law. I love the way this is written. This is probably one of my favorite things that I've read for a news piece in a minute. I love it. Career disruptions. This is more organized than some of the appellate work we've read. Whoever wrote this for Above the Law, who was outraged, you've done this. You've done this better than some recent appeals that we've read. Career disruptions. Many applicants have firm start dates, judicial clerkships, or financial obligations in August that depend on completing the bar in July. Pushing the exam into September destroys start dates and prolongs unpaid study periods. Uncompensated financial losses. Applicants spent significant money to travel, hotels, travel arrangements for Yakima, costs that are not being reimbursed. Mental and physical toll, or otherwise stated, emotional damage. Months of rigorous preparation were derailed by 5 hours of waiting in a hot, crowded convention center with zero answers, only to be told to hold their lives on pause for another 5 weeks. Or more. Or don't become a lawyer. There were other options, all equally shitty. This is crazy. Of course, they say, there is a fourth option that the Washington State Bar did not list, and the Washington Supreme Court knows it well. In June 2020, with the pandemic turning in-person testing into a public health gamble, the court granted emergency diploma privilege to graduates of ABA-accredited law schools, admitting them to the profession without an exam at all. Grads who want a portable UBE score could still sit for a later administration. Everyone else got to start their careers. The sky did not fall. The state went back to the exam the very next cycle anyway, and if there were ever a moment to renew the call for it, a licensing failure so complete that the jurisdiction scrapped its own exam and apologized for the technology it was built on, a class of grads who showed up, did everything right, and were sent home without a test would seem to be it. I don't disagree. Pass them all and let them take the UBE. Let them take the UBE then, if they need to, without additional cost. Also, citing precedent, it's very lawyerly. Cheryl said it in the chat too. We know courts like precedent. Yeah. So, you want to try to mitigate the emotional damage that has been caused? This might be the mitigation necessary. The author goes on to say, but as regular Above the Law readers know too well, tech failures at the bar exam aren't new. California turned a bar exam into a genre unto itself last year. Login failures, crashes, lost submissions, refunds handed out in desperation. The bitter irony writes itself. California's meltdown is a bigger part of what pushed states back towards NCBE and the Next Gen exam in the first place. The Next Gen exam has been in development since 2018. 8 years, and debuted like the ExamSoft catastrophe of 2014, the original bar exam IT nightmare story that never happened. What is new, however, is calling a mulligan on the entire exam before anyone got a chance to answer any question. Yeah, because the California bar exam disaster was also an epic disaster. Well done with the author. I love that it's a screenshot of the email to the applicants. This was written by Catherine Rubinow, senior editor at Above the Law and host of the Jab It podcast and co-host of Thinking Like a Lawyer. Great article. W for Catherine. Literally screaming, crying, throwing up. I don't know if it is just a cruel commentary on the profession of law that when there is a catastrophic failure, somehow all of the shit rolls downhill onto the newest lawyers. And it's like, hey, none of this is your problem, but you're going to suffer the consequences of everyone else's decisions. Welcome to being a lawyer. Or if it is just some kind of, I don't know, cruel test of resilience. But either way, I feel so deeply for these bar examiners and the stress that they must have gone through. It's absolutely horrible. Absolutely horrible. And to send an email with like, hey, here's a bunch of shitty options. Good luck. Good luck. Here's your shit sandwich. I hope you enjoy it. Yum, yum. Like, it's just ridiculous. This is the email they got at 4:53 p.m. The subject line is exam canceled, makeup available. Can you imagine? I can't even imagine. Just the subject line, exam canceled. Dear applicant. Yes, I'm going to read the whole thing. With deep regret, I write to inform you that Washington's July 2026 administration of the Next Gen Bar exam has been canceled. We will not continue tomorrow, Wednesday, July 29th. They left being told they were going to continue and then tried to rearrange everything. And then by almost 5 p.m., we're told, just kidding. Just kidding. Oh my God. Just have a fucking backup. We do not have sufficient confidence that the technology issues have been resolved to attempt administration of the exam tomorrow. We sincerely apologize. The WSBA has been investigating and researching options for applicants. While we continue to explore other alternatives, we have 3 options at this time. Take a makeup exam. I fumbled the words. Hold on. Hold on. Take a makeup exam. The WSBA is working with the NCBE to schedule a makeup exam. It is tentatively scheduled for September 1st and 2nd in Tacoma, Washington. No additional fees will be required to be paid to the WSBA. Oh, hold on there. First of all, you have to travel to another bar exam. That all aside, they didn't say that no additional fees would not have to be paid to the NCBE. They didn't say there that you're not going to have to pay another technology fee. Notice what's left out? Continuing on. Take a makeup exam. The WSBA is working with the NCBE to schedule a makeup exam. It is tentatively scheduled for September 1st and 2nd. Wait, sorry, that's the same screenshot. Okay, point number 2. Transfer your application to the February 2027 administration in Tacoma, Washington. No additional fees will be required to be paid to the WSBA. Withdraw your application. The WSBA will issue a full refund of the WSBA application fee and exam fee. Applicants will need to contact NCBE regarding the technology fee. Please inform us of your decision by email by August 14th, 2026. We understand how hard... Jesus Christ, it gets worse. Hold on. I was not prepared for there to be more. We understand how hard you have worked to get to this day and deeply regret we could not give you a successful exam experience. We will be working closely with the Washington Supreme Court to consider any additional next steps. As always, please contact with any questions, email address, and phone number. Sincerely, it doesn't fucking matter who sincerely signed it. Sincerely, we don't mean to have ruined your entrance into the profession, but holy shit. It's so fucking bad. It's just so bad. It's so bad. The level of trauma. Also, I don't know when the bar shifted to bringing in outside companies to administer the bar, but why? Did we learn nothing from all of the issues we just talked about with the Canvas hack? No, we've learned nothing? Cool. Rory in the chat said, EDB, as an IT technician in a future higher education or further higher education institute, we test any exam software, and everything is either Ethernet. Everything is on Ethernet, absolutely no Wi-Fi. I feel for those IT guys. I feel for the IT guys too, because what I suspect, and this is my pure speculation, I suspect that IT at the venue was not either given a proper heads up or listened to when they raised issues. Because I can't imagine IT knowing that this exam was going to be Wi-Fi dependent for all of the exam takers to all get onto the same website at the same time and didn't either raise a red flag, suggest other options and get shot down, or they weren't told that this was going to be different than past bar testing experiences. So I feel for IT too. I wonder if they were just not informed, which is either on the venue or on the bar examiners for not telling the venue what to expect. I think we have a substantial lack of communication, and the people who suffer the most, I'm sure IT was very stressed, but the people who suffer the most are all the bar examiners. And then for your licensing agency to be like, we regret to inform you that we have completely fucked the next few months of your life. And since you just graduated from law school, we know that the last 3 years of your life were pretty fucked anyway. We have 3 options. Please let us know by August. Bye-bye. It's so unhinged. It's so unhinged. It's so unhinged. And to rely on Wi-Fi for all of the test takers. It's so awful. It's so awful. I feel for the bar takers. I'm curious to see what's going to come from this. I am going to follow the fallout because I'm curious. I saw this headline and I was like, tell me more. Tell me more. What the fuck went wrong? And then when I saw that it was Wi-Fi related, I was like, you've got to be fucking kidding me. You've got to be kidding me. This could have been planned. You've got to be joking. Absolutely crazy. So thank you all for letting us have a minute to discuss the nightmare fuel that was the July bar exam, because it's July and it's bar exam time. Kohberger getting a lawyer, and the TikTok psychic filing her appeal today. Maybe. Like this seems just as bad as like most of the early day Pokemon events where everybody's like, hey, I can't even open the app. That's great. Oh, there's not enough cell bandwidth either. Yeah. Shocking. Absolutely shocking that this wasn't planned for. It's not shocking that it went awry. It's shocking that there was no backup plan. So we're gonna keep an eye on that. Bark said, what happened to UPS Law School, aka the Theodore Robert Bundy School of Law? It became Seattle University. So UPS became Seattle U and moved up to Seattle from Tacoma. All right. Are we ready? Are we ready to move on? Let's move on. Miguelina, will you let the app know that we are switching topics since I was very invested in the fuckery that abounded. Couldn't help it. Super invested. Wanted to know all the things. Yeah. All right. Shall we fly from Washington to Utah? It's a shorter flight, but I think we should fly anyway. Shall we go? Let us go. What in the world is going on with Kouri Richins? Well, Kouri Richins is supposed to have a restitution hearing on Friday. Supposed to have a restitution hearing Friday. It's on the calendar, still on the calendar. But the last thing that we talked about in the Kouri Richins case was the defense's motion for new trial and Judge M's notice. Let's pull that up real quick. Judge M's order sending the case out for consideration. And we have not seen that resolved just yet. So I think the first thing we need to revisit is, can Judge M hear the hearing for restitution on Friday? I don't think that that's going to go well, because Judge M said that he's not going to make any rulings in this case until it's decided if he should recuse himself or not. So the last thing that happened is the defense filed, well, you know what I thought about their motion. The defense filed their bold motion for new trial, spending the majority of that motion saying that Judge M was biased. It was full boo v who. And Judge M's order was not that he was recusing himself from the case, but that he was asking if he needed to. So this is the order certifying motion for disqualification to reviewing judge. Before the court is defendant's motion for new trial. On pages 10 and 11, the motion states in part, quote, because Ms. Richins is asserting herein a claim of bias on the part of the judge, the court should reassign the consideration of this motion to another judge in compliance with the Utah Code of Judicial Conduct. The defense didn't follow the rules to file for a disqualification motion, but here we are. Given the apparent objective bias discussed, the actual conflict of interest created by allegations of the court's bias, and the need to ensure due process, disqualification from ruling on this motion is warranted. The court wrote, out of an abundance of caution, the court interprets the foregoing as a motion to disqualify under Rule 29B of the Utah Rules of Criminal Procedure. They didn't file it properly, but the court said, literally out of an abundance of caution, because you threw it in there that you wanted disqualification considered, but you didn't file a motion for disqualification. So I'm not touching it. Like literally, I'm not touching this with a 10-foot pole. Somebody else can decide. Under Rule 29B2A, the court hereby certifies the motion to the associate presiding judge of the 3rd District for review. The court shall take no further action in this case until the motion is decided. Someone tell me. And when the court said until this motion is decided, I think the court is referring to the motion or the presumptive motion for disqualification. The court kind of fixed it the way the Court of Appeals did for the TikTok psychic earlier this afternoon. The court was like, the vibes are that you're filing a motion for disqualification, but you didn't file it. So I'm going to interpret the vibes and err on the side of caution, which this judge has done repeatedly, and has sent it out. The associate presiding judge of the 3rd District has not made a finding yet. So the court shall take no further action in this case until the motion is decided. Well, the motion to disqualify hasn't been decided, and the associate presiding judge could say, yes, this is a motion to disqualify, but we're not disqualifying the judge. The associate presiding judge could say, yes, this is a motion to disqualify, and we are disqualifying the judge. Here's the new judge assigned. Or the associate presiding judge could say, you're trying to make a motion to disqualify, but it's either untimely or improperly filed, and so yeet. But we have not seen a ruling on this at all. So the court shall take no further action in this case until the motion is decided. There's still a hearing on calendar for Friday. And because there is still a hearing on calendar for Friday, there are actually 2 things on calendar for Friday afternoon. One is the motion regarding restitution for Kouri Richins. The other one is a pretrial conference on her other case. Remember, Kouri has a fraud case, and that fraud case is on calendar for a status conference because now she has a new lawyer in the fraud case. So that hearing might go forward on Friday afternoon, the status hearing on the fraud case. Attorneys Lewis and Nestor aren't on that case. There's a new lawyer on that case. That hearing might go forward. But the restitution hearing in the murder case, unless there's a ruling, can't really go forward. So, what did the prosecution ask for? Let's take a look at their motion regarding restitution. And then there was just a quick order in the fraud case. I think it's just worth noting. The order in the fraud case was that Kouri could appear remotely in the pretrial hearing with regard to the fraud case. So that is what's going on with the fraud case, that Kouri's going to be there essentially via Zoom because she's in prison. So they're not going to transport her for a status hearing. All right. Let's take a look at this, and then I'm going to go and double check the docket to see if anything has been filed, because we have a minute to do that today, and we'll see if there's anything new there. But I'm going to have to log back in and go through a CAPTCHA and all the rest of it. So let's do this motion first. State's motion for restitution. This was filed. What day was this filed? This was filed by Attorney Shervanack on July 23rd, 2026. It took us a minute to get there, but here we are. All right. Statement of relief requested. The state of Utah requests the court issue an order of restitution in the amount of $1,017,018.49 to Auto Owners Insurance and $352,562.61 to True Stage. The defendant's aggravated murder and insurance fraud convictions and the evidence in the record established that the defendant's criminal conduct proximately caused these damages. Statement of facts. Eric Richins died on March 4th, 2022. Auto Owners Insurance insured the life of Eric Richins and, upon his death, paid the defendant as beneficiary the $1 million+ see Day 7 trial transcript, the testimony of Brooke Carrington, and then others. True Stage insured the life of Eric Richins and, upon his death, paid the defendant as beneficiary $352,562.61, and then they cited to the different testimony and trial. On March 16, 2026, following a 13-day trial, a jury convicted the defendant of aggravated murder in the death of Eric Richins and insurance fraud in connection with the True Stage policies. The reason it matters with regard to the True Stage policies and not the auto owner's insurance policy is because that insured his life. She took his life. She's not entitled to be a beneficiary. The Slayer statute voids that. So, argument. Quote, the court shall order a defendant to pay restitution to all victims for the entire amount of pecuniary damages that are proximately caused to each victim by the criminal conduct of the defendant. And then they cite the Utah Code. Pecuniary damages are, quote, all demonstrable economic injury, losses, and expenses. Right. Like all the bar takers in the state of Washington. Those are their pecuniary damages. Economic injury, loss, and expense. All their travel fees. In determining the amount of pecuniary damages, the court shall consider all relevant facts to establish an amount that fully compensates a victim for all pecuniary damages proximately caused by the criminal conduct of the defendant. I mean, that's different than what we're talking about, but in the state of Washington, but it's fair here. We need more water. It goes on to say a trial court's restitution award must rely on a sufficient evidentiary basis. It may award restitution, quote, only in cases where liability is clear as a matter of law and where the commission of the crime clearly establishes causality of the damages. She got paid life insurance for a life that she took. That's helpful because the proximate cause is a straight line. They go on to quote, proximate cause is that cause which, in a natural and continuous sequence unbroken by any new cause, produced the injury and without which the injury would not have occurred. We've talked about this during jury instructions in numerous cases. We're not going to go through all of the ins and outs of proximate cause, but it is very helpful when, your kids are going full Shaggy defense. Excuse me. Oh, that was me. Your kids are going full Shaggy and they're like, it wasn't me. It's like proximate cause. You were the proximate cause of the thing. You can tell me it wasn't you, but you're the proximate cause of the thing. That's it. Proximate cause of the thing. And then we get to the next part. It requires proof of two elements. One, but-for causation. Two, foreseeable harm. So much of the first year of law school, when you're talking about proximate cause and but-for causation, it's like, but for this, did that happen? And then all of the jokes that come from that. Here, the defendant's murder conviction establishes her liability as a matter of law, and the evidence in the record clearly establishes causality. But for the defendant murdering Eric Richins, auto owners insurance and True Stage would not have paid on the life insurance policies. Correct. Their payment was not only foreseeable, but also the defendant's motive for murdering Eric Richins. The defendant's insurance fraud proximately caused True Stage's pecuniary damages for the same reasons. Accordingly, an order of restitution in the amount of over $1 million to auto owners insurance and over $350,000 to True Stage is required. Next, conclusion. Pay. That's the conclusion. The court must issue an order of restitution in the amount of $1,017,018.49 to auto owners and $352,562.61 to True Stage. The defense has not responded to this yet. I don't know if we will see the defense respond to this, but when we first heard discussion of restitution in this case, the state was contemplating whether or not, as a part of restitution, they could recover any of the monies paid to the defense team. They've not pursued that here, which leads me to believe that they've evaluated those options and they are not available to them. And they are looking for restitution for the direct victims here. Remember, when we are talking about other damages Kouri Richins caused, there is clearly other economic damages that Kouri Richins caused, not just related to this case, but those are in the separate fraud case. There's 25, 26 causes of action in that case. So when we're looking at like literally you stole Chelsea Barney's house, like, which always makes me think of early days Real Housewives of Beverly Hills. That is going to be a restitution order in that case, because the restitution order in this case is more directly tied to the murder case. And remember, the court pulled out some of the other financial crimes, which is part of why I was so frustrated when the defense was citing back to Murdaugh and saying, see, too much financial crimes evidence came in this case. They are so different. And the court actually pulled out quite a lot of the financial crimes in this case, so much so in early days of the case that the prosecution went, fine, we'll file all of those in a separate case, and limited it down quite substantially. So her other case, her financial crimes case, is still pending. And yes, Chelsea Barney and other victims can still get restitution there. This also doesn't undermine the lawsuits that are going on with the estate, because if restitution is paid here, I could imagine a situation where restitution gets paid in some amount to auto owners insurance or gets paid in some amount to True Stage. And then the estate says, hey, auto owners, hey, True Stage, those are monies that should have been paid to the estate. We need you to pay those back to the estate, because this is also overlapping where the estate is going after some of these funds as well, because these are monies that should never have gone to Kouri Richins. They should have gone into Eric Richins' trust. They should not have been given to and spent by Kouri Richins. So there is still litigation going on there, but Kouri Richins is not a beneficiary. It doesn't stop the litigation from going on and trying to disgorge those funds from other places. And that's where you see the civil litigation. Here, we can take this off the screen as we're talking about it, but that's where you see the civil litigation of the estate trying to go after areas where the money has been dispersed to and claw it back into the estate and get that money from wherever Kouri distributed it to, including her mother and including her mom's house and more. So that is part of it. Chrissy CC said, this is a great question. Did the insurance double pay? They would have paid the estate benefiting the children regardless. She changed the beneficiaries so that the estate would need to sue Kouri to recover. Kouri changed the beneficiaries. The estate is suing Kouri, but they paid out to Kouri because Kouri changed the beneficiaries. So that's why they're going after it with restitution. And then there would be a phase 2 for that if they ever got paid out. Susie said, where would any of this money come from? Well, that's the next problem. Where would any of this come from? If down the road, Kouri ever wanted to write another book or sell her story in any way, then those monies could go to restitution first. However, I suspect what we would see happen is that Kouri would try to structure those deals so the money goes to her mom, which is why we're seeing in the litigation with the estate also suing Kouri's mother to try to disgorge funds that Kouri funneled to her mom. We talked about this a little in the podcast on Monday because it came up in the David preliminary hearing that after Celeste's remains were found, that David's mother was actively working with some of the money men to move David's home out of his own name into the mother's name and move funds around. So similarly, in this case, we are seeing the estate go after Kouri's mom because Kouri's mom is in a house that was paid for by some of the money that the estate says is theirs. So yeah, I think probably quite a bit of money was funneled to Kouri's mother in addition to property. Getting the property is going to be a little bit difficult, but yes, money getting funneled, future book, etc. So restitution in the criminal sense can be attached differently to things than civil restitution. And then it's always on the books. There's also a way that the state in most jurisdictions, and I do not know specifically for Utah, so there's a caveat on that, caveat on that is that if Kouri ends up with a substantial amount of money being put on her books, there is a percentage amount where that money can be taken into restitution orders and paid off over time. If she gets a job in custody where she's paid, that money can come off and go into restitution and paid over time. And by paid over time, we mean dollars, per month or what have you, but that can happen. So I don't know what Kouri's books look like. I don't know if Kouri has stands that are putting money on her books the way that a Sarah Boone and others do, but that's one way you can get restitution. A few of you, including Cheryl Wright, noticed or mentioned that future inheritance can attach. I imagine anyone that would leave money to Kouri has probably shifted it to Kouri's brother at this point. So I think she probably is disinherited or technically disinherited from that, because I imagine that money's just getting sidestepped. And I imagine that Kouri is like, can you move that around so it doesn't go to them? We saw the way Kouri talked in her letters about her sister-in-laws. I can imagine Kouri doing anything legal, illegal to try to move money around so it doesn't end up in the trust. And the fucked part of that for me is that the trust benefits her kids. That's the part for me that's the most fucked, is that every maneuver that she makes to try to keep money out of the trust is keeping money away from her children. Emily, should we be shocked after she killed her husband? No, we shouldn't be shocked, but it's still appalling. So there's that. So we'll see what happens. I'm more interested in, can this hearing go forward? The restitution will go forward. I think she will be ordered to pay restitution. Don't forget, here, let me fill out this CAPTCHA again. Don't forget that Kouri still has quite a substantial amount of attorney fees she needs to pay for no showing her deposition. I still wonder if Kouri is going to try to sue her lawyers that didn't file the proper paperwork. Because at the time that Kouri, do we remember this? How much detail do we need on this? When Kouri no-showed her deposition, she was in prison and her lawyers didn't file any of the notices that she wasn't going to be at her deposition. And it seemed to be during a period of time that she was represented by counsel. So she and counsel were required to pay attorney's fees as a sanction for no showing the deposition. So I'm wondering if we'll also see Kouri representing herself try to sue the lawyers for that, because she did get hit with a substantial amount of attorney fees in 2 different cases. So I think that Kouri's lawyers failing to say, by the way, she's in prison, we're not going to be at the deposition, is a huge issue. And I think that's bad on the lawyers to start with. So it'll be interesting to see what happens. Or if the estate goes after the lawyers to make them pay the fees, since the reason Kouri didn't show up, this is one of the things that's like not on Kouri. It's on the lawyers. But I wonder if we'll see the estate going after the lawyers for those fees, being like, I mean, it's really not on Kouri to pay it. The lawyers didn't file the paperwork. They were properly noticed, so they should have to pay it. And could the courts make the lawyers pay out of fees that Kouri might have already paid them? That would be interesting. That would be very interesting. So I will be curious to see what happens. The civil litigations are not done yet, even though it was ruled by Judge M that Kouri committed a disqualifying homicide. So some of the litigation has resolved, but not all of the litigation has resolved when it comes to the civil litigation, especially as to trying to disgorge funds. But Kouri still doesn't have lawyers that have shown up in the majority of the civil litigation. So currently she's representing herself in that or those multitude of litigation. And not all the litigation is the estate versus Kouri. Some of the litigation is Kouri versus the estate. So there is still a fleet of litigation, and that will be interesting to see. So 2 things I want to do before we get to just questions, because the restitution request is fairly brief, but I want to pull up the calendar and see if anything has changed since we've been live this morning. I had a couple appointments this morning, which is why I was later getting started. For all of you that had the app, I hope that notification worked really well to be like, hey, you don't see a video on the channel yet. Don't worry, it's coming. I'm just not there yet. So hopefully that heads up worked, which with summer schedules, the app really is the best way for me to keep you in the loop with, yes, we're streaming, it's just going to be a little bit later, or yes, we're streaming, it's going to be here or there. It helps me keep y'all in the loop, as schedules are just, everything is much more settled when we're not weeks away from DCI finals and Travis moving into college all in one breath. That's all just one weekend. DCI finals are like Thursday to Saturday, and then he moves in on Monday. So it's much, but also there is just, it's summer. There is stuff. So I'm glad that worked for you guys. Just of a like, hey, heads up, so you can also plan your time as well. Let me pull up the, where is it? Let me pull up the calendar so I can show you if that's changed since yesterday. I don't know if it has or not. So again, I love to just be able to show you like, hey, this is what the calendar still says. I do not think that we will see the restitution hearing go forward if we don't have a ruling on the motion to disqualify. I have not seen a ruling on the motion to disqualify, but hey, it's only Wednesday. I mean, I guess in theory that could happen today or tomorrow. Let me just check the docket. I don't see. There's a new filing on the docket. 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 They ruled on the request for disqualification. Miguelina, ping the app. They ruled on the motion for disqualification. I said, unless they rule on the motion for disqualification, we are not going to have a restitution hearing on Friday. And they ruled on it today. Oh boy. I'm going to have to change the title of this video. Hold on. We're going to do that again. Oh my God, they ruled. I can't believe they fucking ruled. That never happens. That ever. Oh boy. All right. Well, we're going to ping the app. I'm going to go change the title of this because we don't always do breaking news, but when we do, I hope it's worth it. Oh my goodness. All right. Well, the court has ruled on the request for disqualification. Don't worry. We're going to use the bumper. I'm going to change the title of the stream real quick, just so anybody who's cruising around the interwebs has a chance to see it. Let's see. Breaking. Emily, you're putting it in all caps. Nightbot can't yell at me in my title. Let's see. All right. I'm going to change this real quick. We're going to let the app come in and we're going to I'm going to download this so we can have it. Let's see. Defense request to disqualify. That's crazy. Unless, hello, judges of the 3rd District. Hey, so dropping this ruling while I'm streaming is also a massive W, and you have earned my and the Law Nerds unyielding gratitude because we have been waiting to see what happens to everyone who just put, I am yelling Carl in the chat. Yes, I am yelling Carl. New ruling. Hold on. We're just going to put ruling on defense disqualification let's see. Judge. All right. Oh my God. Oh, everybody who's just coming in. We double-clicked the docket. And damn, I'm so glad we did. What I was just saying is that we were going to check and see if the restitution hearing for Kouri was still on calendar. And the restitution hearing for Kouri Richins is still on calendar. And I said that the only way that could go forward is if the supervising judges had ruled on the request for disqualification. We read Judge M's order just a few minutes ago where Judge M said, it seems like the defense wants a motion to disqualify, so I'm sending it to y'all. Y'all decide if I need to be disqualified or not. And that was, well, that's kind of everything, because the defense spent all of their motion saying that Judge M needs to be disqualified from hearing the motion for new trial, because they spent the whole motion for new trial saying, but Judge M was mean to me. So as I was pulling up that calendar to just show you that the restitution hearing was still on, and to say, I don't think that the restitution hearing is going to be going forward on Friday. The prosecution's asking for over $1.3 million of restitutions from Kouri Richins. I was saying, well, these hearings are still set, but I wondered if they would get changed because there hadn't been a ruling. And then when I clicked back to the docket has a ruling. So we are going live now to find out what the reviewing court said. Put a 1 in the chat if you just came in because you got pinged by the app. I'm so glad I went through the CAPTCHA again. Put a 1 in the chat if you're just coming in from the app so that I know if we need to, excuse me, a lot of you. All right, so I'm going to go back through Judge M's ruling one more time. Thank you for hanging with me, those of you that have been here. We're going to go through it one more time, just real quick, and then I am just downloading this ruling real quick. So thank you all. Look, I try to be organized, and then we have new things happen. Organization is required. This just came in. It wasn't in this morning because I checked before I left for appointment. So this just came in Utah this afternoon. I am just my flabbers are gasted, and I am so glad it happened while we were live. This document is taking a moment to populate. So I'm getting just a spinny wheel, but we're pulling it up. So let's look real quick for those of you that just came in. Hi, good to see you. Welcome back. Much has happened today, but what we were talking about was the defense. Well, we were talking about restitution, but the defense saying, hey, we think Judge M should be disqualified. And they never made a motion for disqualification. We went through that in other content. Judge M said, out of an abundance of caution, it appears to me that the defense is asking that I be disqualified. And Judge M said, this court, Judge M, shall take no further action in the murder case until the motion with regard to the disqualification is decided. And I said, well, as I was saying, we're going to get to questions. Well, I guess they could rule between now and the restitution hearing on Friday. And they did. I am stunned. So let's see if it's still spinny wheeling me. Oh my goodness. How are we still getting a spinny wheel from this motion? How are we getting spinny wheeled? Hold on. Oh, the technology is fighting. I'm not trying to build suspense. I'm truly not. I am getting spinny wheeled, and I am pissed about the spinny wheel. So let's see if I can get this to download, because I am just getting spinny wheels. Oh, it's so rude. The technology is just spinny wheeling me. So give me 1 second. I don't know if it's too, I talked about the state bar exam and now it's just fighting with me. Hold on. Let me see if I can just pull it up a different way and get it to download, because it is just absolutely fighting. I feel like everybody who's like, it's like we're in Washington. I feel like we're in Washington because the spinny wheel is so incredibly rude. So incredibly rude. All right. That is just frustrating. You know what it is? It's because it's not the Wi-Fi. It's my account. That's fixed. It's my account with the state of Utah, because there's a fee to download each document, and my account at the moment was 30 cents short. So I had to repopulate that real quick. That's what the spinning wheel of death was. That is so annoying. I didn't even think about it yesterday. They only let you refill it like $10 at a time. They have documents available online. Emily, they have documents available online. The documents are available online, and we love them for that. We love them for the documents being available online. We love them. We love them for that. But yeah, they want my 30. They want my 30 cents. So it wouldn't download. All right. Let's see if we can now get this to, okay, now we are downloaded. Now we are saved. Now we can proceed. That was so annoying. I'm sorry, chat. I did not mean for that to be suspenseful. It normally goes so fast. This is why don't do breaking news. Because I really just want to be able to prep things. Just the state of Utah is like, give me my dollar. It's like, can I give you 20 cents tomorrow? Oh my God. All right. Streaming is dynamic. All of you who asked, is it on Pacer? It would have happened much faster if it was on Pacer. All right. They have their documents online, so we get to do things live. We have new documents, new filings, everybody, new order. Let's go. Let's go. Emily, do we just play like Blue Monday and totally roll the dice with the copyright guides? It's too important. Not today. Not today. We have a new filing. So this is, wait, what window is it in? It's in the wrong window. Emily, put it over on the other screen. Oh my God. I am yelling, chat. The title of this motion is Order Denying Request for Disqualification. Well, spoilers. Filed July 29th, 2026 at 12:44:36 p.m. on, well, that would be Mountain Time. Oh my. Can you imagine how awkward it's going to be in court? Oh, that's going to be so awkward. That's going to be so freaking awkward. Oh boy. Oh boy. I can't wait to see what they say. So let's get into it, shall we? This is from the reviewing supervising judge. Before this court for decision is a request to disqualify Judge Mrazek pursuant to Rule 29B2A of the Utah Rules. Hey, B2. Good to see you. You're going to hear your name a lot. We did this last time. Hi there. Yes, we're back. Pursuant to Rule 29B2A of the Utah Rules of Criminal Procedure, the judge against whom a motion to disqualify is, quote, directed shall, without further hearing, enter an order granting the motion or certifying the motion and affidavit to a reviewing judge. Remember when we reviewed all of this? What was the first thing y'all said? But there's no affidavit. Right. They never made a proper motion to disqualify. They just kind of buried it and were like, vibes, but you should be disqualified. I wonder if they thought that Judge Mrazek would just like yeet himself. Because remember, this has two parts. The judge can grant the motion or can pass it to another judge and ask that judge to review it. Do you think that they thought that Judge M would just like acquiesce to their request? Maybe. Judge M did not grant the motion, but instead, on July 1st, 2026, he certified the request to me as the reviewing judge as part of my responsibilities as associate presiding judge for the 3rd District Court. See the certification, Docket 1787. We just covered Docket 1787. As pointed out by Judge Mrazek in his certification, the request for disqualification is contained on pages 10 and 11 of defendant's motion for new trial. Bold strategy. Let's see how that plays out, shall we? The court has reviewed the materials submitted by defendant in support of the disqualification request, including Exhibit A. The court awarded receipt of Exhibit A, or the court awaited receipt of Exhibit A to render this ruling. Exhibit A was provided to this court on July 17th. No. No. No, 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 no. No, 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 no. What in the world? That's what the delay was? Girl. The motion was filed and Exhibit A was sealed, but the motion for new trial was filed on what, June 28th? I'm going to go pull up that motion. Sorry, June 30th. So June 30th, the motion was filed and they waited until July 17th to receive Exhibit A. Oh, okay. Okay. Emily, what was Exhibit A? I'm going to go back into the docket. And no, Exhibit A is not on the docket because Exhibit A was sealed. Oh, it was the video. It was the video. It was the video. And we went through different parts of the video together when we covered this motion. And we watched probably more than we should. But we watched the video that was on a thumb drive. So I'm just going to pull up the defense's motion so I can double check, but I'm pretty sure that's what Exhibit A was. Did they not call it Exhibit A in their motion? Well, I can't control F to what Exhibit A is if you don't call it Exhibit A. Did I spell it like the cat dad? No. What did they call it? Attachment A? Yes, they called it Attachment A. Okay, it's an exhibit. Emily, that was a visceral response. Correct. This is what the defense says Exhibit A is. See Exhibit A, a video clip of trial day 4. The court interrupts Miss Lewis. This is in a footnote, by the way. The court interrupts Miss Lewis in a demeaning manner, saying, "Please pause." Seconds later, the court follows an interruption of the prosecution with an apology. When Miss Lewis expresses frustration at the court for changing a ruling made at the bench, she is told twice to stay focused and don't do that. Please stay focused. The video clip of trial day 4. We pulled it up when we went through this motion the first time. Oh boy. All right. Oh, that's the wrong motion. Hold on. The court waited until July 17th to get the thumb drive with the video. Okay. Exhibit A was provided to this court on July 17th. The court enters its ruling as follows. Rule 29, procedural requirements. We clocked this immediately. The second we read the rule, we clocked it. Rule 29B of the Utah Rules of Criminal Procedure sets forth the following procedural requirements for a request to disqualify. The motion shall means must. Shall be accompanied by a certificate that the motion is filed in good faith and shall be supported by an affidavit stating facts sufficient to show bias or prejudice or conflict of interest. We clocked this immediately. We pulled up the rule on stream when we went through this motion and we were like, well, they might yeet it on procedural grounds. Or they might yeet it on procedural grounds and say, even if those had been included, we don't find it sufficient. The court goes on to say the disqualification request is not accompanied by a certification of good faith, nor is it supported by an affidavit or unsworn declaration. Thus, it is procedurally deficient and is denied on that basis. Maybe they should have taken the focus to heart a little bit more. But it says it right in the rules. We pulled up the rules. And it says if you're making a motion to disqualify, this is what's required. And I think I told a story about how when I worked for judges, I would go to the judge and just be like, they're supposed to do this and they didn't. Yeet. You have to follow the rules. They're supposed to provide this and they didn't. And if it was something that was easily fixable, font size being wrong or whatever, we would normally just say, for future, here's the local rules. This is not a small thing. A certification of good faith and a sworn affidavit are large procedural requirements that the defense fundamentally failed to meet because they didn't file a proper motion. So they spent almost 14 pages panning a judge and then saying, you need to recuse yourself, and then failing to properly file a motion to disqualify. Ouch. That's going to hurt. The disqualification request is not accompanied by a certification of good faith, nor is it supported by an affidavit or unsworn declaration. Thus, it is procedurally deficient and is denied on this basis.
Liar!
Oh, wrong one. Hold on. Also.
Mention it all. Mention it all.
Because the motion isn't done yet. Timeliness. You know this is one of Emily's favorite factors, not for her own life. Emily, the hypocrisy. I know. The rules of court are simple and finite. Timeliness of motion per Rule 29. If anyone says, but it was a leap year. Timeliness. Rule 29 requires a request to disqualify to be filed no later than 21 days after the last of the following. B1, assignment of the action or hearing to the judge. B1, appearance of the party or the party's attorney. Or B1, the date on which the moving party learns or with the exercise of reasonable diligence should have learned of the grounds upon which the motion is based. We clocked that too. And we said in this scenario, we're going to end up in B1, which is when do they believe the judge was exhibiting bias? And they went through the different trial examples. Well, that means you have 21 days from the example of bias that you are citing to file the motion to disqualify. But they asked for extension after extension on their motion for new trial and then spent literally 11 out of 14 pages arguing that the new trial should be granted based on the judge's bias, but they never filed a motion to disqualify the judge. And it would have been yeeted as untimely. So that's kind of a womp womp. Hold on. Where's our
not today, Judge.
Or maybe not today, attorneys. Oh, they're not even done yet. Oh, God, I appreciate this judge. Here's what this judge did. This judge did not just say, based on procedural grounds. This judge said it's denied on procedural grounds, but wait, there's more. Let me answer all the other questions for you. So just in case you had procedurally done it right, which you didn't because there was no affidavit and there was no certification of good faith, but even if you had done it right, let me address this on the other grounds for you. So even if you had done it right, it's still untimely. And their next header is even if it's not untimely, let's look at the grounds. Timeliness. With respect to the instant request, the last applicable date would fall under subsection 3. The date defendant knew or should have known of the grounds upon which the motion is based. The grounds asserted for disqualification is the conduct of Judge Mrazek during trial. The last day of trial was March 16th, 2026. Thus, the motion filed on June 30th, 2026 was filed more than 21 days after defendant learned of the grounds upon which this motion is based, and it is untimely. Untimely! 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 The motion is denied for this reason as well. Untimely! Law nerds! Look at us. We came up with all the right answers. We said that both of these things were going to be a problem on stream. And Judge, is it petite? Is the last T silent? So it would be petit? I don't know. Kara, I'm not sure. Judge Petty? Petite? Petit? We love this. Grounds. So here's what the court said. First of all, it's procedurally deficient, denied. Second of all, it's untimely, denied. Third, the grounds for disqualification, which means the judge has decided that even if the procedural grounds were there, I'm going to tell you what. Because even if the procedural grounds were there, still no. I love the I'm going to tell you what. Grounds for disqualification. Last, even if, this is the arguendo, even if the motion met the procedural requirements of Rule 29 and was timely filed, it fails to state sufficient facts, or it fails to state facts sufficient to show the level of bias, prejudice, or conflict of interest that Judge M required to warrant a disqualification. Are we going to get to citing Boo versus who? Boo versus who? Boo versus who? Boo versus who? Chad says it's Pettit. Fair enough. But Petty's funnier. Pettit is probably correct. So the judge takes the arguendo to say it's denied on these procedural grounds, but even if it wasn't, like, don't go appeal the untimely of it all because it's a waste of your time. Because even if it was done right and even if it was timely, still no. The facts are still a no for me, dog. So, too bad versus so sad. And this is why spending 11 of 14 pages trying to pan the judge is such a terrible strategy. And then to not even file the motion procedurally properly and to not even file it timely just is like pulling the pin and putting it at your feet and then seeing what happens. It's just such a terrible idea. But let's find out how terrible this judge thinks it is. Defendant argues, under the case of Boo versus who, that Judge Mrazek should be disqualified from ruling on her motion for new trial because Judge Mrazek is biased and because the motion is based in part on his alleged bias. Motion at page 11. Judges are presumed to be qualified, and a party alleging bias on the part of the judge has the burden of demonstrating the judge is not qualified. And then they cite the case law. The Utah Code of Judicial Conduct requires a judge to enter disqualification when, quote, the judge has a personal bias or prejudice concerning a party or a party's lawyer or personal knowledge of facts that are in dispute in the proceeding. Emily, what does that mean? Like, if a judge was driving to work and saw a car accident, the judge can't then be the judge on the civil trial regarding the car accident. The judge is a witness. If the judge is friends with one of the attorneys, like close, not acquaintances, like close friends with one of the attorneys, or married to one of the attorneys, they can't hear the case that attorney is arguing. There are ways that this comes up. Or personal bias. You see this in cases with publicly traded companies. If the court owns a ton of stock in a particular company, they shouldn't be deciding the civil suit that may impact that company's stock. Things like that. Does that make sense? Hopefully all those, all of you are like, no, keep going. We want to hear about the facts more. Fair. But that's what they mean. They go on to say that Utah's Code of Judicial Conduct contemplates disqualification where, for instance, the judge... Keep reading, Emily. Just keep reading. The next line, the judge just breaks it down. I didn't see it, and it's single space, so it's harder for me to see anything. The judge keeps explaining it for the defense or defendant. Utah's Code of Judicial Conduct contemplates disqualification where, for instance, the judge is related to a party or an attorney, has a close social or professional relationship with a party or an attorney, is involved in the case at hand before becoming a judge. So like if they were a lawyer handling the case, or has a financial or property interest that could be affected by the outcome of the proceeding. In other words, the bias or prejudice must usually stem from an extrajudicial source. Right, outside the case, not from the occurrences in the proceedings before the judge. Keep this in mind in other cases where sometimes it seems that the judge on the case is maybe not the judge that would be ideal on the case. Just keep this in mind. The bias or prejudice must usually stem from an extrajudicial source, not from occurrences in the proceedings before the judge. It is a difficult standard. The judge's behavior, they cited case law there. Sorry, the case law says the same thing. The case law says, quote, the alleged bias and prejudice of a judge must stem from an extrajudicial source and result in an opinion on the merits on some basis other than what the judge learned from his or her participation in the case. Gigs, I'm going to answer this as we get to the end of this. I'm going to talk about how the YSL judge got yeeted because I think it's a helpful distinction here. So keep that standard in mind. A judge's behavior toward a party during court proceedings must be extreme to warrant a finding of prejudice under Rule 29. The Utah Court of Appeals has held disqualification is warranted, quote, only when it appeared that, apart from the judge's analysis of the issues of fact or law, he had such a bias in favor of one party or prejudice against the other that he could not fairly and impartially determine the issues. That is, the affidavit must allege facts indicating that, quote, the judge's behavior towards a party during proceedings was extreme and reflected a deep-seated antagonism toward the party requesting recusal. And then it states the case law for that. Defendant alleges that Judge Mrazek was impatient, critical, hostile, disparaging, and condescending towards defense counsel, and in contrast, was friendly and helpful towards the prosecution. That's exactly what was argued. But when you put it like that, Your Honor, yeah, that's exactly what was argued. But the audacity of arguing it. The audacity of arguing it. Like having the actual unmitigated gall to argue that Judge M was impatient, critical, hostile, disparaging, and condescending is insane. We've gotten to like rubber v. glue, but also there were times that I found the defense to be impatient, disparaging, condescending, and at times to really move a very fine line on candor with the court. So the audacity of the thing. And the court here just put such a point on it, didn't they? See motion at pages 3 through 10. The court finds the video excerpts of trial provided by defendant on Exhibit A and the trial transcript references in the motion do not demonstrate the level of extreme behavior or conduct reflecting a deep-seated antagonism towards the defense, nor favoritism towards the prosecution to warrant disqualification. Even if Judge Mrazek's conduct could be considered as showing anger or frustration with defense counsel, that is not grounds for disqualification. The judge is one step away from being like, he was just matching your energy. And he didn't even do that. He didn't even do that because he was so patient. When the defense was amping things up, he would say, don't do that. Pause. Let's not go there. And try to bring the energy back down. He would not enter the fray with them and patiently and consistently asserted a boundary. And they just banged their head against that boundary the entire trial. That was their choice. But he was so patient. But I appreciate the even if. They go on to state case law that says judicial remarks during the course of a trial that are critical or disapproving of or even hostile to counsel, the parties, or their cases ordinarily do not support a bias or partiality challenge. The court finds and concludes Judge Mrazek's alleged conduct falls well short of, quote, revealing such a high degree of favoritism or antagonism as to make fair judgment impossible. For all the foregoing reasons, the court concludes defendant has not demonstrated grounds to disqualify Judge Mrazek, and her request is denied. This is the order of the court. Well, counsel, arguing this motion is going to be real interesting. Arguing the motion in front of the court is going to be fascinating. This is going to be fascinating. So that's an L for the defense. The judge told them to focus and stay on topic. He told them to pause when they were bridging from one topic to another. When they were making arguments, he clarified those arguments to make sure that he was responding to the argument that was being made, showing that he was engaged in listening to both sides. When the defense made an argument that led him to do more legal research, he would bring back that legal research, even if the defense hadn't cited it on the record, and oft rule in their favor based on things that they tangentially said, because it was the correct result under the law. Sometimes it was the more cautious result under the law. Do you think the defense now maybe feels in their soul what a takesy v. backsy motion would look like? Or do they not remember? I wonder if the defense doesn't even remember takesies v. backsies. But I think if there was ever a moment where the defense would be thinking that a takesy v. backsy motion is warranted, this might be the moment where they want the takesy v. backsy. So Fletcher Boy asked, why didn't they present a defense at trial? Because the defense believed that it was in their best interest to leave the case where it was at the end of the prosecution's case, because they would have opened the door to much, much more. CEG, the rebuttal case in Sarah Boone. They thought that it was in their best interest to keep the case narrow and where the prosecution left it. Had they put on more witnesses, there were a bunch of doors that had already been wrecking balled that would have brought in a lot more information. They also knew what the prosecution was holding on to that they had not used in trial, and they made a strategic choice. I think it was their smartest strategic choice. But the rebuttal case, based on what we know now, the rebuttal case could have been more devastating for them than it was. So, that's why I think they strategically chose not to put on a case. And I think they made that decision early on because the defense kept trying to get into their direct examination of the state's witnesses instead of calling those witnesses in their case. They tried very hard to have their cake and eat it too. And the prosecution wasn't letting them do that. I wonder if they'd gotten away with that in other cases, but they were trying to get into direct examination of witnesses. The prosecution did, I think, a great job of keeping their case narrow and focused on their own case, and said correctly, if they would like to get into these topics with these witnesses, then they can call these witnesses. The only time they allowed the defense to do a direct examination style questioning of a witness was with Miss Staking. She was the only one. And I think her being from out of town had a part of that, because having the witness fly back is a different thing. So they allowed for that. Do I think that at some point we will see Kouri's appellate counsel complaining about the procedural deficiencies here? It's possible, but it's not going to go anywhere because the court said there are procedural deficiencies here. But even if there weren't procedural deficiencies here, it's still a no. And so the court walked through the procedural deficiencies and then walked through the facts and said it's a no on all three. It's a no, it's a no, it's a no. So, so now, Emily, who is going to be ruling on who is going to be ruling on the motion for new trial? Judge M. It's going to be Judge M. It's going to be Judge M. So, the court has denied the supposed motion for disqualification. And when the hearing gets set for the motion for new trial, we will be there. And it looks like game on for Friday then. Unless between now and then the defense files a motion to continue to figure out WTF is next. So that's going to be awkward and interesting. I just can't wait. I can't wait to see what happens. This is there are things this defense team has done that I have never seen before. They made what seemed like very personal impact statements for Kouri. They were not attorney argument. They seemed like personal character impact statements, which was wild to watch. But then the strategy they chose with the motion for new trial seems so odd, to spend the majority of your motion just trying to burn it all down is a crazy strategy. So the defense's you should disqualify yourself, Your Honor, did not work. And the reviewing court said, hey, we didn't even get the thumb drive of the video until July 17th. This motion was filed on June 30th. And less than 10 days later, we get a ruling from the court just in time for those hearings on Friday to now go forward, because Judge M had said, I will take no further action in this case until the motion to disqualify is ruled on. So what happens now? Well, we have to wait till September for Bloodworth to respond to the motion for new trial that's going to be heard in front of Judge M. Oh boy. Oh boy. What does an entire Bloodworth motion of, you were there, Your Honor. The defense did all these things to antagonize you. Oh boy. That's going to be interesting. The balance the prosecution will walk is that they are still prosecuting another case with Kouri Richins. But it will be interesting to see how they argue that motion for new trial. Oh, I can't wait. I can't wait. I can't wait. I can't wait to hear, to read, to share with you all that motion. I'm waiting for that. Oh, it's going to be so good. And none of this would happen if the defense hadn't chosen the strategy that they did. So this is going to be fun. They have given Bloodworth too much runway to have too much fun with. The difficulty is going to be keeping it within the page limits and narrowing down the don't threaten me with a good time of it all. Because there's so much runway there. Libby in the chat said, Emily, can the defense claw that motion back and say, forget about it? Not really, because not making a motion for new trial isn't really a option. So no, I don't think they can, because they would have to ask for leave to file a new motion for new trial. And I don't think they would get leave to file a motion for new trial. They already asked for leave for an extension of time to file this motion. I can't imagine that the court would allow for that. Yeah. But do I think they might want a take CV backseat? I don't know. There were times that the defense seemed so caught in fight mode that they could not read the room. And it's why I go back to the take CV backseat moment, is that I think defense was so stuck in fight mode that when Bloodworth kind of cracked a joke of, before the break, the prosecution said we were going to do A and B. After the break, we need a take CV backseat because we're not going to do A and B. And the defense was like, I don't even know what case he's citing. And the court's like, I think it was a joke. Like, you could see these moments where the defense is just so locked into fight. Like, get out there and kill. That the defense was just so locked into fight that they could not see what was happening around them. And so for those of you who have not read Dungeon Crawler Carl, I'm sorry. The reference was to that. I realize it's out of place for those of you that have no idea what I'm talking about. But I do think that they were unable to take a step further back and see the forest. I think they were just beating their head against the tree, being like, why won't the tree move? And that is a problem for any attorney. If you are too locked into fight mode, you cannot critically think. It's somewhat analogous, I think, to watching, I don't know, pick a competition reality. To watching competition reality. You watch Survivor, you watch Amazing Race or what have you, and you look at what people are struggling with, and you're just like, how can they not figure out that puzzle? Or how can they not do this? Or can't you do that? Because they are under a level of stress and fight or flight based on game mechanics that it makes it hard to critically think. And it's one of the massive aspects, right, of competition TV. Those who are able to work within fight or flight or suppress their own fight or flight can make better decisions. But those who can't have a hard time making decisions. So even simple tasks when you're sitting at home with your popcorn, it looks really easy and they can't figure it out then. And so lawyers can end up in the same trap. And there are lawyers, when they say kind of play your opponent, I don't think that happened in this case. I think the defense played themselves. But there are lawyers who will play their opponent so that their opponent is kind of locked in fight mode and can't see the bigger picture. You law in court, you have to be aware of the courtroom, aware of how the jury is responding if you're in a jury trial, aware of the judge that you're in front of and how they're interacting, and aware of the other side. And we've seen plenty of instances of lawyers pushing each other's buttons. And you can throw your opponent off their game by pushing their buttons. Law in court is not different in that way from sport, where athletes try to push each other's buttons and play to the refs that they have. And good lawyers are able to do that without getting pulled into it. And there are some lawyers who are very skilled at letting opposing counsel think that they've pushed their buttons. Well, they're still kind of above it and a bit disconnected from it. But if you let somebody pull you into the mud, the only person who wants to be in the mud is the person that's pulling you there. And not all lawyers adapt well to that circumstance, especially when they let it get under their skin. You cannot let it get personal. Which is why I think lawyers who were athletes have, especially trial lawyers who are athletes, have somewhat of an advantage there because they are used to being able to adapt in that way. And a lot of my colleagues at the DA's office had been high-level athletes, either in college or some professionally, or had hobbies in like combat sports. Just pick a combat sport, because they had a lifetime of practice of not letting it get personal, or realizing that when you let it get personal, you don't perform your best. It puts you into like aggro mode and you just don't perform your best. And when I say athletes, I also think this covers for gamers too. Like if you let people talking shit in a Call of Duty lobby throw you off your game, trial work's probably not for you. If you can listen to a Call of Duty lobby talking shit and just zone it out, you're probably not going to get your buttons pushed by a judge or another lawyer. So with all of that, I think we saw that in this case. I don't think we saw the prosecution poking the defense at all. I think we saw the prosecution with like almost blinders on to the whirlwind that the defense was trying to spin up. Like the defense was a spinning tornado of whatever. And if another attorney had gotten swirled into that, it could have taken them off their game. I think Lally's a good example of that. I think Lally got spun in the, rinse cycle of the defense in that case and pulled Lally, I think, a bit off of his game. And I think Lally's way of compensating for that was witness one. Where were you on day? What was the weather? What was the time? And so Lally just kind of stuck both feet down and was like, there's no flexibility here. Witness by witness, question by question, that's it. There's no reading the room. We're just head down and doing. Then in Reed Part 2, I think we saw two defense attorneys on either side of the V poking back and forth at each other, some more successfully than others. But in Richins, we saw the prosecution doing a very good job of like putting up a force field and not getting swirled into the defense's stuff and just focused on their case. And I think the defense was so in their own swirl that they could not see what the prosecution was doing, and they could not take a step back and see the case. And I think that was to their detriment, truly. So that's a long way of saying, where are we at the end of the day? Well, the defense is going to get to argue to Judge Mrazek's face that he was mean to them. That's where we're at the very end of the day. At the very, 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 very end of the day, the defense is going to have to stand up and argue their motion to Judge M's face and say, Your Honor, it's not fair. You told me to pause. It was rude. Ash Nicole in the chat said, Emily, I saw a news article that one of the jurors said Lewis had reached out to her to get her trying to say that she was wrong. I covered that when we covered the motion for new trial. So it's there. So Friday is supposed to be the hearing. I'm going to reach out to the court and see if there is going to be access for it. I will keep you updated in the Law Nerd app if we're going to stream that on Friday, either in real time or later. So I will let you know in the Lawnerd app, what we're going to do with that, which will be interesting. I'm going to get to some of your questions. I think hopefully the recap was helpful. You guys have a bunch of questions and we will get there. So let's chat now that we've gotten to go through the court's motion of like, denied. But it's going to be the first time the parties are in court together since this motion was filed. God, I want to be a fly on the wall. I want to watch. I want to know so much. I'm so ready. All right, Lawnards, let's chat. All right. There was a great question earlier on that I saved that I wanted to come back to. MM Gigs asked, how did the YSL judge get yeeted? If you did not follow the YSL case, do not worry about it. I'm going to try to answer this question where you don't need any underlying knowledge of the shit show that was that trial. But when the motion for disqualification says shall, we're going to take a look at it in this court order because it illustrates the same point. The law, and we're looking at Utah, it is very analogous to Georgia. But the law says that the judge against whom a motion to disqualify is directed shall, without further hearing, enter an order granting the motion or certifying the motion and affidavit to a reviewing judge. So if there's a motion to disqualify, everything has to stop. Do not pass go, do not do anything else. Everything has to stop, and the judge either has to grant the motion or send it to another court. And the YSL court did not stop. There was a disqualification request, and he kept doing things on the case. And because that judge did not heed the shall, I think there were other things that warranted disqualification, but the reason he was disqualified is because when the motion for disqualification happened, he didn't stop doing things on the case. And ultimately, that was the reason he was removed from the case. Because the law is very clear. Once that motion for disqualification is in, you stop and either grant it or send it to another judge. The YSL judge did not. And that's ultimately why he was disqualified. In the middle of trial, where did I put I don't even know. Things are wandering off my desk. So that's why. That's why he did not adhere to the pause. He did not heed the shall, and then went on to do a bunch of stuff in the case. It was basically like, nah, I'm not going to do that. When it comes to disqualification, all of these rules say shall. All of them. Because if you're saying that a judge has to be disqualified, that judge shouldn't be able to make rulings that could substantially impact your rights until it's decided whether or not they have to be disqualified. And that includes that judge ruling on it being untimely. If that judge isn't going to grant the motion, that judge doesn't get to say this is untimely necessarily, depending on the way the motion is brought. It goes to another judge to review. And this can happen as easily as an attorney who's been on the case for 3 appearances wants to file a motion to disqualify the judge. Well, the attorney's already appeared and the case has already been assigned to that judge. So what the judge has to do is say, okay, you can go have this heard down the hallway. And the other judge is going to look at it and be like, that's untimely, go back down the hallway. Because untimely is one of the big reasons these get bounced, but the judge doesn't do it themselves. B. Josie, this is a great question. Doesn't that create bias though? No. The defense saying, we think you need to be disqualified, and the other court saying no, means that the judge is unbiased. Not means that they have found that there's no bias to remove the judge for. So now the judge gets to hear the motion. It's why the lawyers have to strategically decide the motion. I think most lawyers, not all, and most judges, not all, can put themselves aside This is also probably why the profession has deeply unhealthy coping mechanisms, but that's a conversation for a different day. But I think most lawyers and judges can put themselves aside and just rule on the facts. It is something that you start doing in law school. It's why lawyers are fairly familiar with arguendo. Sometimes you will watch cases and be like, how can they even argue that? Because they've taken their own feelings out of it entirely, or should have taken their own feelings out of it entirely and are looking at it through a much more calculating lens, because you have to be flexible to be an attorney. And if you want to do trial work, and not everybody does, but if you want to do trial work, you have to be able to maneuver in that way. So no, being able to file a motion accusing a judge of bias and then going, but because I said those things about you, now you're biased, would be a system glitch that would allow for gamification to get around the rules to properly disqualify a judge. It would allow for essentially a do-over where any attorney could just file a motion saying, but the judge was mean to me, and then create the situation to get what they want, even if they don't follow the proper rules. So no, it does not create bias. And again, I think most lawyers and judges can sit there and be like, I mean, that's a bold strategy, but okay. I also think this case is a really easy example of this because we watched it play out. And Judge M telling the defense to pause, there was not a moment in that where I sat there and went, oh, that's a little, like, Your Honor, really? What are we doing? And that does happen in cases when I look at the court and I'm like, oh, okay, Your Honor, sure. This is not that case. It's just not that case. And I think the court is able to clearly see what happened in trial. So no, I don't think them saying that the court is biased creates a bias in and of itself. So Rando from Iowa said, I thought he was nice to the defense. He was incredibly patient, just incredibly patient. Kendra said, I maintain that Ramos needs to be sanctioned, not for appealing to his religion, but for standing up and saying the jury was wrong. If you have no faith in the jury, you should not be a lawyer. There was a lot that was very weird about Ramos's statements. I was also kind of appalled at the disrespect to the jury. There were a number of things that he did that were unexpected. So I hope that as Ramos becomes a more seasoned attorney, that will go well, and that he will learn. But it does feel like the defense team got very sucked into Kouri, which is also an error. If you are too pulled into your client to step back and see the case clearly, you do everyone a disservice. And I think we saw some of that in Depp v. Heard as well. I think we saw, especially with Elaine Bredehoff, a very stressed attorney trying to deal with a difficult client and it not going well, versus the Depp team who seemed to be 100% behind their client, but not in a way where they couldn't maneuver in the case. And it was a very different thing watching the way Elaine moved through that trial with I'm a ride or die for my client, and how stressed she seemed, versus the Depp team that also had very much the I'm a ride or die for my client, but the energy was so much different. They didn't seem frantic. They were more poised in the way that they were carrying that out. And there is a difference there. You can be 100% in your client's corner, but the best way to do that as an advocate is to be able to see the best part of your cases and the worst part of your cases, and sometimes to be able to see the worst part of your cases almost more acutely, because that is a better service. So, but Elaine was trying. She was trying. Slushy/fun said, bold strategy, Cotton. Yeah, we're going to get to see how that plays out. It's going to be so good. It's going to be so good. I'm here for the tea at this point. Just, how are you going to argue? How are you going to argue this motion in front of this judge? We're all just going to sit there and just be like, okay. Either that or the defense will show up in court and be like, we submit on the papers. We submit on the papers. That's an option. That's an option. Gamer818 said, love your streams and appreciate your legal breakdowns. These streams inspire me to choose to become a paralegal here in Utah. That's going to be amazing. Good luck. Thank you. Also, you really need a goddammit donut soundbite. Goddammit donut. I know. We probably do need a goddammit donut soundbite. Chat, I think, also wants a Mongo is appalled. So we'll see. Jimothy the Raccoon, this is 10 out of 10. Are you using the Yakima Convention Center Wi-Fi to download it? It seemed like that's what they were trying to do. It seemed like that was what they were trying to do. And I can't even help with the back in my day, because I took the bar so fucking long ago. It doesn't really help. But we had to download everything for the bar in advance. And then I think we got a thumb drive. We had to have the software and everything downloaded. And then I think we got a thumb drive with the exam on it. I don't quite remember. It was so stressful. I'm not surprised that my brain is I don't even remember what happened. But we had to have all the bar software already on our computers before we showed up. There was a whole thing. But I don't remember how we then accessed the exam. And then I took mine on computer, but there was an option. You could take it written or on computer. I could type and think better than handwrite and think. And I liked being able to paragraph edit. So that was easier for me. And I didn't want to worry about someone not being able to read my handwriting well when I was stressed. So I did that. So Emily said, we scar tissue over trauma, but you do remember Disneyland. I do remember Disneyland the day I passed the bar. Also, I have rarely in my life cried that hard ever as the day I passed the bar. The relief held on until November. And then it was just boo-hooing in public. Oh, it was a whole situation. I was embarrassed for myself, but also it was coming out one way or the other. It was just coming out. I didn't throw up. So there was that. Celebral82, thank you for the 10 gifted memberships. Virginia, thank you for the 10 gifted memberships. We are going to have to figure out when we are doing our members only if we're going to go to court on Friday. So I have some scheduling things that I need to figure out, but I want to go to court. I want to go to court on Friday. I do. I want to go to court on Friday for sure. Vicky said, my husband can do that. Remove himself from an argument. Me, not at all. Vicky, I will just offer for me, I am very, very good at not taking it personally when I am in a certain capacity. So if I am in court for my job, very good at it. If I am saying what are we doing here? If I am in a group and I'm just hey, yeah, so this isn't going to work for us. Very good. When it is just me, for me, I tend to opt out of conflict. One of my favorite, Emily inserts herself into conflict stories. I will tell you in just a minute. Amy's bucket list. Did you use ExamSoft? I think it was ExamSoft, but I don't quite remember. But when I have inserted myself into situations, it is much easier for me to be dispassionate. When it has to do with me individually, I tend to just be whatever, it's fine. Just whatever, it's fine. Just whatever, it's fine. I'm not doing it. When it's other people, I definitely pull out the sword and a shield. When it's me, I tend to let it go because it's just I'll be fine. But one of my favorite And for those of you who know this story, I'm sorry for telling it twice, but one of my favorite Emily inserts herself into things that are none of her business was a day that I was a little... Emily, isn't that every day? I was running late to court. I didn't have to be in court. Hold on. My things are falling. The tech is fighting me. God damn it. Mouse pad. I guess I don't need to specify that I was running late to work, but Emily was running late to work. Be shocked. I went to my local Starbucks a couple times a week, sometimes twice a day. It was close to my courthouse. I liked the Starbucks. I liked their staff. I pulled up to go in and get a drink. And one of the Starbucks employees, I think was the manager, but I don't quite remember. But one of the Starbucks employees was telling an individual in front of the store that they needed to leave. And that individual was engaged in some type of picketing activity and was trying to I don't remember if it was tell people to vote for something or not vote for something or hand out pamphlets or whatever it is. It was some type of picketing activity, not specifically related to Starbucks. Either way, dude was getting into people's business as they were trying to walk in on the way to work to get their morning coffee. I imagine what happened before I got there was that a bunch of customers went into Starbucks and were like, excuse me, whatever is happening out here is just not welcomed. People are trying to talk to me and block my way to get in to get coffee. And he was blocking the door to get in to get coffee and getting into people about whatever the thing was. Pretty big guy, a pretty tall guy, getting frustrated with this Starbucks employee who was a little bit shorter than I was. I'm already why are you yelling at her? Stop it. I'm 5'6". She was probably 5'4", 5'5". Dude was 6 foot, whatever. But also don't accost people before they've had coffee. And so as I'm walking up, I hear him starting to explain very loudly that he has the right to, and I am on my way to work and I really like this employee. And I'm like, well, actually, this is a private parking lot that is run by 3 different businesses. So it's very technically not a public sidewalk. The funny thing about this story is that the other side of the Starbucks has 2 entrances. The other side was actually not in a private parking lot. It was on a public sidewalk. It was facing Rosecrans. But the side he was on was inside the private parking lot. And the Starbucks employee was like, sir, we've had multiple complaints. This is private property. We've asked you to leave multiple times. Look, people are just trying to get their coffee. You're going to need to leave. I have a First Amendment right to be here and say whatever he was saying. I have a First Amendment right to be here. This is a public space, and I can stand wherever I want, and some additional variation of it's a free country. And so then I'm standing there. I have not said anything. I have not walked into Starbucks, and I am just standing there. And I'm like, okay. I saw a couple of you asking. I am a Taurus sun and a Taurus moon and a Virgo rising. And very ADHD. And so I'm standing there and he busts out the First Amendment, and the employee's like, sir, we've asked you to leave. We just need you to leave. And he is not going anywhere. And then busts out I have a right to be here. I know the law. I'm a lawyer. And I said something to the effect of, oh, what kind of lawyer are you? And he just looks at me and is like, excuse me? And I'm like, what kind of lawyer are you? He's like, what? I'm like, you just said you were a lawyer. She said that she was asking you to leave, and you just said you were a lawyer. What kind of lawyer are you? And he kind of hoed and hummed about it and didn't tell me what kind of lawyer he was. I'm like, no. Are you licensed in California? Because what kind of lawyer are you? Also, what kind of dickhead, not a lawyer, I'm sure, but what kind of dickhead is yelling at a Starbucks employee while there is a morning coffee line when they have asked ever so nicely, hey, all of our clients are complaining. Can you just please go? Thank you. It's private property. Like, man, I just work here. Can you go, please? So he doesn't answer my question of what kind of lawyer he is, but then turns his attention to me and says, what does it matter to you? And I'm like, well, you're yelling at this Starbucks employee and you're yelling at her that you're a lawyer and that you have a right to be here and that you have a First Amendment right to be here. I am also a lawyer. So I'm curious how you think you have a First Amendment right to picket on private property, because it's really clear that this parking lot is private property. And in fact, it's posted on numerous signs around the parking lot. So I'm just curious, what kind of lawyer are you? As a fellow member of the bar, because I'm also an asshole. And if you're going to go there, we are going to go there. And it is going to be great. Because why? Because Emily did not have to be in court that day. Emily had to be at work, but Emily did not actually have to be in court that moment. So, as a fellow member of the bar, I'm curious. And he's like, this is none of your business. I'm like, I have a First Amendment right to stand on this sidewalk as a patron of Starbucks, which I'm about to walk into. But your discourse on the sidewalk has delayed me in getting my morning coffee. And I think that the employees had asked you to leave, as is their right, because this is not public property. And he goes, I have a right to be here. And I'm like, well, it sounds like she asked you multiple times. And I think I actually looked at the employee and said, it sounds like you've asked him multiple times to leave. She goes, I have. And I'm like, it sounds like then he's trespassing. And I look at him and he goes, I'm not trespassing. I'm like, well, they've asked you to leave multiple times and you haven't. So this is private property. It sounds like you're now trespassing. And he's like, this is none of your business. I have a right to be here. I'm going to call the police. And I was like, were you saying this? Colty Clips asked, were you saying this so calmly? Oh no, because I was speaking more quietly so that he had to lean in to hear me. Because I match asshole with asshole. And yes, because what are you going to do, dude? Like, what are you going to do? You're going to stand out here and scream at a Starbucks employee while everyone's trying to get their morning coffee and then be like, I'm a lawyer. Fuck you. No, you're not. What are you going to do? What are you going to do? Also, I was within the jurisdiction of where my courthouse is. So, am I maybe a little bit emboldened that everyone on patrol in this area knows who I am and I have most of their cell phone numbers? Perhaps just a wee bit emboldened. Perhaps just a wee bit emboldened with that knowledge. I was also in my suit, like ready for work. Also, how dare you stand there in all your 6 foot whatever self screaming at a Starbucks employee over private property? Sir, she doesn't make the rules. Just fucking leave. So when I say that If this was someone having conflict with me, I probably would have been like, whatever, just go get your coffee. You are undercaffeinated, sure. But you have raised the mama bear heckles in me of how dare you. So he said, I have a right to be here. I'm going to call the police. And I was like, please do. And he just looked at me. And I was like, go ahead and call the police. Because then they're going to trespass you. And then they're going to assist you in leaving. So you could either just leave or you could call the police. And he's like, I'm going to call the police. I'm like, you don't need to keep telling me. Just call the police. Which police are you going to call? Because I think technically we're in El Segundo, but we're kind of abutting Manhattan Beach. So which law enforcement department would you like to call at the moment? Go ahead. Call the police. And he's like, I don't remember what else he said, but I was like, never mind, I'll do it. And he's like, what? I'm like, I'll call the police. Was I calling dispatch? No. No, I wasn't going to call dispatch. So was I going to call the police? Yes. Hey. Yeah, no, you on duty at the moment? Great. No, I'm at Starbucks. Yeah. They're having a bit of trouble with the trespasser. Yeah, no, I haven't made it to court yet. I'm still at Starbucks. Do you guys mind swinging by real quick? Great, that'll be great. See you in a minute. It's so weird that he left before they got there. It was so weird. It was so weird. He was just gone before they even got there. It was so fucking annoying. I was really pissed. I was like, God damn it. Stay here and get trespassed. They're not that far away. I want to watch them yell at you. Come on. I was so pissed. I was so pissed that he left. Yes, I bought them coffee for showing up, but I was so pissed that he left. I was so mad. But then I told the Starbucks, and at this point, I physically stepped in between the Starbucks employee and the dude. And I was like, they'll be here in a minute. And I looked at her, I'm like, you and I are going inside. So we went back inside. I'm like, they'll be here in a minute. Because also I knew that if we had stood there, he probably wouldn't have left. And the goal was that he left. I'm like, look, you need to call corporate or whatever and describe him. And if he shows up again, you need to write down everything that happened today. And I would make an incident report with corporate or whoever so that if he comes back, he's already been given notice that he's trespassing and you can just call the police if he shows back up. But I like physically stepped in front of her and was like, we're going inside. Because I figured if we stay outside, he's probably not going to leave. The goal is for him to ultimately leave. If we go inside, it gives him a moment to like make a different choice before it all escalates. I don't want it to escalate. I just want you to fucking leave. If we stand out there and force the issue, he probably wouldn't have backed down. And that can create so much more of a problem. And my goal was not to create more of a problem for the Starbucks employees. My goal was for him to fucking leave and then never to come back to that Starbucks again. But the second he was just like, I'm a lawyer, I was like, pardon me. So, what? Talk to me. Talk to me. So then when I got to work, people are like, hey. I'm like, hey. They're like, how was your morning? I'm like, good. Today was a good day. Didn't even have to use my AK, though was never carrying an AK. But today was a good day. They're like, what were you doing? I'm like, I mean, there was this dude being a dick at my Starbucks and I couldn't let it go. And my coworkers were just like, that tracks. Because sometimes you just have to insert yourself into other people's business. Do I advise that for everyone? No. This is a very specific situation where, first of all, I was within the law enforcement jurisdiction while I was working and knew every single officer in both jurisdictions, the area I was in straddled, well, and had most of them in my cell phone. So does that make it a little easier to be like, go ahead and call the police? Would you like me to call them? I know everyone that's on day shift. Let me call them up and see if they're busy. I didn't call any of the canine officers, which I think shows a great amount of restraint. Also, I was like, bet. If I had been in a jurisdiction that wasn't mine, I probably would have also called dispatch or told the Starbucks employee to go inside and just call the dispatch line for the non-emergency line for law enforcement. But it helps when you have the contacts that you can call and say, hey, also, this was years ago, before anybody's busting out a cell phone to record and escalating this to the point where it might have been unsafe, which is also never anyone's goal. It's never anyone's goal to be unsafe. This dude thought he had an advantage, I think based on size and height, and then trying to say that he was an attorney. I don't think he actually was. And so I was like, you don't even know what my skill tree looks like, sir, but okay. Because the injustice of it all. But I don't want it to escalate. And also, I really just don't want people being fucking annoying at my Starbucks and disrespecting the employees. Like, goddamn, it's hard enough to be a service worker. Like, come on. Liaising with the public is not easy. Sir, stop making it worse. So I did not call the canines. All of you agree that the canine unit shouldn't have been called, or should have been called so the pup could get a pup cup. I mean, I don't know if the canine officer that I'm thinking of at the time would have pup cupped his dog while they were on duty. It probably would have just annoyed his dog. And that, again, dog can escalate things. Dog can de-escalate things, but dog can escalate things. So the goal, again, is to just de-escalate things. Again, it was a different time, and I absolutely had home court advantage. But if I can use home court advantage to try to step in between somebody being abusive in that way, also, I was pretty confident he wasn't going to take a swing at me, so that helps. I was pretty confident he was not armed. My situational awareness is fairly good. Also, the closer in time I was to playing water polo and still doing a lot of boxing and kickboxing, the more I was just like, I mean, all right, I guess. The further away in time I am, the less I'm just like, yeah, I don't want to mess with that. So when I say that arguing for myself does not always go the same way as arguing for others, that Emily just inserts herself into other people's business comes up quite a lot. But also, there are times when you look at a situation and you know you can't de-escalate it. He was trying to reason with the Starbucks attorney about why he was right. He was being loud and he was being physically intrusive of his space, but he was not being like Daryl Brooks level of unhinged, because then I would have just looked at the employee and said, get inside and call the police. But he was trying to make her back down based on a perceived knowledge advantage. And I was like, no. So do we do that as much anymore? It just depends on the situation. If somebody's getting feisty at the snack bar, yes, I will move over a few windows and be like, hey, what's the problem? Just talk to me. I got people skills. Either that or I will just be louder. One of the two. It just depends. So it just depends, again, on the circumstance. But also, EDP can make things happen. So there was one other time where I did talk us out of getting a noise ordinance ticket at a PTA party. They even let us finish up. It was fantastic. But EDB can get things done. Yeah, we can get things done. We got people skills. Talk to the people so that the engineers don't have to talk to the people. There was a DJ at the PTA party. But most things can be resolved. Look, most people don't want conflict. There was a DJ. It was an 80s party. There was a DJ. It was on a Saturday. It was in a backyard. Somebody's unfun neighbors were mad about the DJ noise. So they called the police, and the police showed up. What's PTA? It's a fundraising arm of the school. So parent-teacher association, they're called different things in different jurisdictions, but it was the kind of situation. This has taken off more since we have moved in California. It does not go down quite the same way in Middle Tennessee. But in California, these things have gotten quite extravagant, where a family chooses to host a party and they host the party. And then the parents buy tickets to the party from the PTA, and that's the fundraiser. Your ticket money goes to the school. The family foots the bill for the party, and you show up or don't show up. So I think the neighbors were invited. I just think they were like, me. So we handled it. It was fine. But again, I was happy to show up for an 80s party, and we still had time until the noise ordinance was done. But the parties have gotten quite elaborate. So it is more fun than wrapping paper sales, and it's social. And if parents are willing to do it, not everybody wants to host, but if they can, they can. AdCommit, that area of California didn't have HOAs like there are in other places. So no HOA to worry about. And this was a community that did a lot of block parties where you petition the city to like close down your entire block so that people couldn't drive on it. It just a different thing because no HOAs. Either way. But what is the long and short of it? Arguing sometimes is easier when you're not arguing on your own behalf and it's not personal and you just want to solve the problem. Because at the end of the day, I am a problem solver. Sometimes I can be absolutely salty. And when those things align, I'm just like, oh yes, let's. And I get particularly ruffled when people are being awful to anyone who works in a public-facing job. If you're mean to a flight attendant, I will probably say something. If you're being a dick to a server at a restaurant, I will probably say something. Like, why do you think you can just be unhinged to people? It's not cool. Just stop it. They're trying to do their job. Let them be. Also, they generally don't have control of the rules. Just, if you're going to wild out on somebody else. It's a skill issue. Just talk to people. But again, easier when the person's trying to be kind of a jerk, but is not unhinged. I do not advise ever stepping in without proper training when people are just not grounded in reality. That can also get difficult. All right. So with that, Law Nerds, I'm going to check in about Friday. I will let you know in the app what's going to happen because I am going to see if there is access for court on Friday. I will keep you posted in the Law Nerd app about what happens. I will be interested to see if the defense files a motion to continue because that will be super interesting. And we'll go from there. If there is going to be court on Friday, I very much want to cover it, but it's afternoon court, so we'll just have to see. I will take a look. So I will let you know what's happening. Law Nerds, thank you for rolling with me today. It was going to be a quicker day, and then we had live filings. Huzzah. We talked about not taking arguments personally. Also, getting to choose to engage is a lot easier. Like when that's chosen for you, it's way less easy to navigate. And I think lawyers choose to be there. No one accidentally ends up in court litigation. That there a lot of choices have to happen to get there. And sometimes ridiculous hurdles like the state of Washington canceling the motherfucking bar exam. I haven't even got to talk to Judge Abby about it. I can't wait to call her and be like, you're never going to believe this. Because she's been on vacation and I'm sure has not seen the news about the state of Washington just yet. So, Law Nerds, you are the best. I love having chats with you. I love being here live as we're like, oh, let's just refresh the docket and see what happens. And then just, oh my God. Oh my God. We got to fly to Utah. We got to fly to Washington. Today was a good day. I will see you tomorrow or Friday. I will let you know in the app at the end of the day today once I find out if we're going to have access. And with that, take care of yourselves. Take care of each other. I'm so glad to be here with you. And thank you for being a Law Nerd. Go get the Law Nerd app so you can stay in the loop. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop. Because you never know when something's going to pop off. Thanks for being here and thanks for being a Law Nerd.